Members, it's 5:30, so I'll declare the meeting open. To the gallery, hopefully you can hear me well. My name's Don Donaldson. I'm the presiding member of the panel. The other members here is Councillor Robin Pearce, Ryan Pereira, Rob Gagetti and Will Gormley. Okay? So we comprise the panel and we're here to decide on planning applications before us. Bit of housekeeping. If I could ask everyone to have their phones off or on silent, if need be, and I hope we're not here all night, there are toilets just around the corner behind you there. And if there is a fire alarm, staff will evacuate us to the Vine Street Plaza. Okay. Now, I presume this isn't an everyday event for a lot of people here in terms of coming to a panel meeting. So just a bit of explanation. We are appointed by the council to decide on various planning applications, particularly those where there are objections to be heard. Okay. Now, we're appointed by council, but we have a very distinct function. Okay, you elect your elected members, either state members or local government members, to represent you in a broad range of interests. Okay, the panel's function is not like that. Okay, we're here with a very specific task to determine applications based on planning guidelines, either in the development plan, what's called a development plan, or the planning design code, in accordance with legislation, taking into account things like case law and characteristics of the locality and the like, as well as the concerns that might be expressed to us from residents or objectors. Okay. Now, importantly, there are some things that the panel, because of court decisions and the like, will not be taking into account. And I know these have come up in some of the objections we received. So, two specific matters that have been raised. One is devaluation of property, and the other is impact on health, okay, because of the particularly the tower that we're considering tonight. Those matters cannot be considered by the panel. So I would encourage people, when they come forward to speak on such matters, to concentrate on what we can actually take into account and their planning considerations of amenity, visual impact and the like, okay? Now, we have a number of applications to deal with tonight, some of which you will obviously be called forward to speak in support of your representations. Your name will be called by me. You will be invited to come forward and you will have up to 5 minutes to outline your concerns. We have your written statements and we have viewed the sites in question. So please, when you do come forward, speak to the main issues that concern you, okay? Because 5 minutes generally goes fairly quickly and you need to make the most of that time. That's why I'm suggesting please don't spend a lot of time talking about devaluation of property or impact or your concerns about health. They're not matters that we will can take into account. After you've had your say, there may be questions of you, but if not, I would ask you then to take your seat in the gallery and I will call the next person up. Eventually, the applicant will also be called forward and they will have the same opportunity of presenting their case and answering questions if we've got any of them. The panel will then go ahead and determine the applications. We also have staff here that support the panel that we may have questions of them as we deliberate as well, okay? Particularly with the telecommunications tower, there are considerable numbers of people wishing to speak. we're here to determine the applications on and the objections on their merit. It's not a case of numbers adding to the weight of your case. So if someone has already presented the points that you are wishing to raise, then by all means consider whether you merely want to say, I support what so-and-so has just said, okay? We don't have to hear it a number of times for it to be considered by us, okay? That's all I've got to say, except that, members, given the interest in one particular application, I'm wondering if we could bring forward that application and consider it first. So that would be bringing item 8.1 forward to this first item, which is the telecommunications tower. Is everyone comfortable with that? Okay, right. Now, before we get into the applications, I would like to acknowledge that we are on the traditional country of the Kaurna people of the Adelaide Plains region, and we pay our respect to elders past and present. We recognise and respect their cultural heritage, beliefs and relationships with the land, and we acknowledge that they are of continuing importance to the Kaurna people living today. Members, there's no one on leave and there's no apologies. Can I call for confirmation of the minutes of the 11th of July meeting? Will? Rowan? Put that motion. Those in favour? That's carried. Are there any conflicts of interest that need to be declared? I've yet to receive any. So, Neil? Okay. All right. Let's move to item 8.1. It's for 84 Main North Road Prospect. It's a mobile telecommunications facility comprising a 30-metre high monopole, antennas, equipment cabinets and ancillary equipment. Now, to the gallery, I'll start calling out names to come forward and speak. There's two chairs there for the representatives. If you'd like to just come forward when I call your name. Theo Giancopoulos, and my apologies for mispronouncing names. Theo, are you here? Okay. Charles De Luca. Tom and Lisa Coultis. Okay. Sia Orman. Would you like to come forward, Sia?
I won't take up too much of your time.
No.
I think most of it's in my actual oops. Most of it is in my application, which you guys have already read, and I'm sure you're taking into consideration. But for me, it's the impact on the actual street and the apparent lack of. I understand it needs to be in a certain position, and it needs to be where, obviously, in the communication network. But considering that that across the road is commercial, there's a commercial all the way down the street. The radio rental site where it was previously is now being redeveloped also as a commercial site, which would be an appropriate site to replace it in that exact same position where it was before, which wasn't suggested that it was an issue. And also, that's and basically what I put in my application as well. So I don't want to take too much of time. I'm busy.
So your concerns are visual
and impact on the surrounding properties, in particular the residential ones. I'm further down the street, but also I'm not quite sure why that particular site was chosen, considering the location across the road. Scotty's, there's a medical centre across the road. There's lots of other areas within that location or locale that it could be or put back where it was, essentially, as well, considering that site's now going to be a commercial site. Not long, so.
Well, I'm sure we'll hear from the applicant about those matters as well.
Absolutely.
Sorry, Sia, you?
Yeah, as I said, it was pretty much what was in my report, and obviously wanted to support the rest of the community. So.
Any questions, Sia? Thank you. Sorry, to the gallery, I should have mentioned this meeting is being recorded on YouTube. There are a number of people that couldn't make this evening and caught at home, be it illness or other reasons. So we're taping it at the moment, and you'll be able to access it later as well. David Lloyd. Now, David, you had a presentation as well?
Yes, we're representing two people, myself and also Jody May. Thank you very much for hearing this, as these have been put forward already. Jody lives right next door to the proposed location there, which is the Crowley site on the left. So what we'll be doing is, in this particular representation, applying the case of the appropriateness of the Planning Act or the Planning Code and some case law, which has been put together by some legal help.
David, just before you start, and it doesn't count in your time, I just also wanted to make clear, people that are representing others don't necessarily get 5 minutes for each of the person they're representing. And I should have maybe mentioned that earlier, David. So I might give some leeway, but it's not, David, if you're representing two people, that you've got 10 minutes, okay?
Well, I better do mine first then, because that's not what I understood to be the case. I understand why you would say that, but I'm not going to go on. It's very, very succinct.
Okay. Well, let's see how we go.
No, it's very succinct. I'm a planner, so
right. Okay. Go ahead.
Fire away. Okay, so this is just a visualization demonstrating what will occur. Please, next slide. That's obviously the 30-metre monopole, plus there's a head frame above that, which goes above 30 metres. That is probably 5 metres from if 5 metres, as we've set this up here, from that person's, from Jody's backyard there. I'm sure none of us would like that to occur. Next, please. That just demonstrates that boundary there is the residential zone. And the other side, that is the piece. So what we've done here is we've put together some discussion, really some points, just saying that, as demonstrated in Jody's submission, this development would contravene the Planning and Design Code and contravene Supreme Court case law. The next slide, please. So in terms of the Planning and Design Code, the site located on the boundary, as I've just suggested, of a sensitive residential zone, also within 74 metres of an existing telecommunications tower, breaches some of the following outcomes from the code. Sorry about reading this. That's just another visual demonstrating that tower I've just discussed. That tower is directly behind number 42 College Avenue, which I happen to own, but doesn't bother me there. Next, please. The site, so in terms of infrastructure and renewable energy facilities, desired outcome 1, a site located in this proximity to a residential zone does not minimise hazard, does not fail the culturally sensitive requirement, and does not manage adverse visual impact on residential amenity. That's very important, the amenity component of the discussion. Next, please. Again, really, so we're looking now that it does, in terms of being within 74 metres of an existing tower, it does not minimise hazard. Again, it fails culturally sensitive requirements, and again, does not manage adverse visual impact on residential amenity, effectively making it a kind of industrial zone. Next. So looking at another point, really, just in terms of the Planning and Design Code, really the impact on nearby public roads, residential areas and places of high public amenity are also impacted significantly. Next. The proposed site contravenes many express objectives of the code, and it's clearly inadequate in this case. Next, please. In terms of some support from the Supreme case law, as it says here, I'm not going to go into the background of this so much. Telecommunications facilities located and designed to minimise visual impact on the amenity of the local environment. PO 6.3, telecommunication facilities, particularly towers and monopoles, are located and sized to mitigate visual impacts. In this particular case, there's been very little, if any, attempt to mitigate the visual impact of the tower with screening. In fact, it's probably impossible to do so. Let's go on next, given the nature and the size of this monopole. What we have done is in my previous one, last time this came through, I have a strong background in GIS, and we did a spatial analysis of it and looked at better sites in terms of what would have less impact on immediate boundaries on residential, and we found a few of them. There'll be a discussion later on tonight, a more conclusive presentation than mine, that will go into some of the alternative sites that we've looked at, and had owners suggest that they would be open and amenable to location of the monopole there rather than where it is. So the important part there is the planning authority will need to consider where alternative sites or low impact facilities are suggested, whether that minimisation could be better achieved by installation of a facility at another preferred site, which is really a strong point of the case that I put forward. Next, please. You'll also need to consider whether that possible preferred site will meet the facility demand. Now, this is an interesting point. There would need to be some assessment of the extent to which an alternative proposal might minimise visual amenity as well. But what happened in the original case of this was they said that they wanted to move, as the previous speaker said, from the site sitting at Radio Rentals, and it had to be within 200 metres to be able to be effective. This is actually outside of their own requirement of 200 metres for the new tower, which what we're going to demonstrate in a minute is that we found what we believe to be a much better alternative. Move next one, please. It is indisputable that a site adjoining a cemetery better manages adverse visual impact on residential amenity than the site on the boundary of a residential zone. Therefore, minimisation can be better achieved by installation facility at another preferred site. Again, we'll move on. So this is the point that I just made prior, is that they actually said at the first case that this should be relocated within 200 metres of the radio rental site. Next, please. So there's a diagram showing that. So the circle represents 200 metres. The original tower Radio Rentals is located there. You'll see below that is the existing tower that's located at the telecom facility in Ballville Road, and then the proposed site for Crowies, which is outside of the 200-metre zone. See number 83 Main North Road there? That backs onto a cemetery. It's surrounded by commercial. It's in the urban corridor zone. The owners of that property have said that they're amenable to relocation there. There are some issues associated with that site, but none of that we can demonstrate that those issues have all been overcome in other examples of what we're doing. Moving on, please. So therefore, 83, that green site we suggest is one of the better sites that we could look at as an alternative. Next, please. Okay, let's move to mine and I'll try and fly through that.
Sorry, are you raising different points?
Yep. There'll be some, but those that are covering this, I'll skip right through, okay? I understand. Next slide, please. So I have a master's degree in urban planning. I'm ex-planning SA and I'm a landlord. That's my interest. Landowner and landlord in Prospect. Next, please. Look, the residents strongly oppose the development proposal. Next. We recognise the need for technology and demand for growth and implementation. Next. We oppose the proposed location of such a large community. This is important. It's not that we are against technology or monopoles. It's just that the planning code should look to site these in the most appropriate location wherever feasible or possible. Next, please. As I've already said, it's being proposed to be put up within 5 metres of an existing residential zone. Thank you. Again, recapping on that previous one, you'll see there's 74 metres from an existing tower. Next, please. And previously, there was about 40 metres from the tower located on, sorry, I'm getting tongue-tied, Radio Rental site, existing tower 2, whereas now it's within 5 metres of someone's back door. Next, please. So how's it going to look? We can skip through this because we've already done it. Thank you. Again, that's just to go back one, please, just for a moment. Thank you very much. So that's a view from Main North Road. In one of the previous proposals, I said trees would screen that, and it's not going to be immediately obvious. That's obviously not the case. That second tower, the monopole, the one proposed at the moment, is a significant blight on the amenity of the area. Next, please. We've already highlighted the inconsistency of the nature of this application when compared directly with the adjoining zone. Thank you. Character overlays reinforces the valued streetscape characteristics through contextually responsive development. Okay, we know what that means. It's about character area statements, and it's about the amenity of the area, not being so intrusive. Next. I'm not going to go through all that. This will be covered by other people. I imagine it's already in my writing. So effectively, it should be sited within quality spaces and integrated within the public realm. This is clearly a case of what's going to be best for the proponent, and it certainly hasn't taken into account community consultation or issues. Sorry, moving on. So this is the zone that it is proposed within. Again, we're really just talking about one of the big issues here is the interface between zones. So in this case, the desired outcome should be that development is located and designed to mitigate adverse effects on or from neighbouring and proximate land uses. Clearly, in this case, it is not. Next. There's a small point here, one that's valid nevertheless, and that's that the house I looked at, Jodie's house, has got a large solar unit on the roof, and this will directly overshadow that unit at certain times of the day. And in the plan, it says it should not unduly reduce generating capacity of adjacent rooftop solar energy facilities, taking into account those items. Thank you. Setbacks, we're going to fly through this. Moving on, please. There is a thing over here on adjoining zones where you shouldn't extend against 45-degree envelope in terms of what should be desired construction. Moving on, thank you. That's the poll. Next. And this is out of planning and development. Brian. Thank you. So look, I'm winding up now. So there are 3 sites that we've looked at. You notice that all of those items, everyone approached in those 3 sites has said yes. They've been approached, yes, they've responded, and they're amenable to the thing. Next. I'm nearly done. All right, I know you. Thank you.
Covered all the points that you seem to. When you say you've approached all these people,
yes,
you mean you've or your group has approached them?
We'll discuss that in person later on. I shall stay away from that. So alternatively, so we've suggested further investigation will yield a better outcome for all parties. I'm being Captain Obvious here. So just a quick diagram. Here we go again. The original tower, there's the proposed site. There's the 200-metre radius again. Thank you. There's the existing tower, which does create an issue. And next, that shows you that there's a double overlap in terms of that area there. And you can see that the amount, we can't talk about health, but we can talk about amenity. Those 2 towers close together is clearly a very, very poor planning outcome, and certainly one for the amenity of the city of Prospect. Next.
Okay. This, you're hitting us over the head with it. There's really nothing new.
Yeah, there is. Next one. Next one.
Okay, let's see.
That site we're talking about.
That's the alternative. Yep.
All right,
which you've covered.
Yeah, but you haven't seen it, and I think it's important that we show visually rather than for people that don't understand the planning issue. Next, please. So next to, and we're done. There's another site that we've looked at. They are the other 2 listed in that list. Moving on. Again, please. All of those things. Next. Would your kids want to live under that? Thank you very much for your time.
Are there any questions of David? Nope. Thank you.
Thank you very much.
Mayor David O'Loughlin. Hey, David. 53.
Thank you, Chair and panel members. Acknowledge all the panel members here tonight, including Councillor Pearce, who you've mentioned, but also in the gallery we have Councillors Barnett, Tobacco and Brood, as I've missed somebody else who might have turned up. I'm here representing the council who have made a decision regarding this project. It's unprecedented for a mayor to appear before this council assessment panel. I'm not aware of any mayor doing it elsewhere in the state either. I could be wrong, but it's unprecedented for this council. We're not opposed to phone towers, not opposed to monopoles, but we're only in favour of the right place, and this is definitely not the right place. We oppose this proposal because of its proximity to residential backyards, its proximity to a character zone interface, its failure to comply with a 50-metre zone setback prescribed in comparable zones. It's twice the height of the prescribed development height for the zone. It significantly exceeds the prescribed building envelope, a line 3 metres high and 45 degrees back on the boundary, which is the case for every residential property in this city and on zone interface boundaries. The proposal vastly exceeds that simple rule of that 3 metres and 45 degrees and should be refused on those grounds alone. The corridor zone doesn't anticipate or name phone towers as a potential land use. My understanding is that this doesn't preclude them, but it does require any such proposals to be assessed more carefully, a performance-based assessment, in other words. It's Council's strong and unanimous view that this proposal fails that test. I note the applicant's response to the various issues raised by the many representatives, and we refute their responses as follows. One is they say it's as near as possible to the previous site. It's not. It's just been demonstrated. We think there's over 5 alternate sites with undeveloped land closer to the previous site. For example, the office work site, not yet named, is not fully developed as stated by the applicant, has a significant landscape reserve on the main North Road facade. The former subway site, also not mentioned by the previous representative, appears very suitable. It's immediately adjacent to the Telstra site, but it's been dismissed due to the need for a 50-metre separation to the Telstra facility. So it appears distance does have some relevance in this discussion, but only for the proponent. However, this site, the subway site, could easily resolve the 50-metre setback from the Telstra tower by placing the tower on the main North Road side of the site, replicating the exact location that previously occurred on the top of the radio rental site, where it was effectively on the front facade. It's implausible that this site hasn't been discussed in further detail by the proponent, where we think that would be eminently suitable for a co-located tower with both Telstra, who's clearly their tower is under capacity, and Optus, and anyone else that wanted to be on a single tower rather than create a second tower. It beggars belief also that the tower, a new tower, can't be accommodated within the existing Telstra site. And I just want to make clear that there's no letter or advice provided by Telstra that they will not consider either of the above options as required by the legislation. I disagree with the statement of the proponent that it will not create impacts that the building envelope standard is designed to mitigate. It considerably exceeds the building envelope of that 3 metres and 45 degrees. That is entirely to stop large buildings being overbearing on a zone interface, which this absolutely is. I agree with the staff report, which recommends refusal. I note that there's a number of requirements of the Infrastructure and Renewable Energy Facilities Code, PO 1.1 in particular, that requires them to be located and designed to minimise hazard or nuisance to adjacent development and land uses. I can only interpret create a nuisance as being its visual nuisance. It clearly does create a huge visual nuisance. And it really imposes on backyards. These are backyards where people entertain their friends and their family, where kids play. There's no doubt that those people will find it a nuisance to them. And similarly, clauses PO 2.1C, 6.1 and 6.3, you've seen them demonstrated already, all combined to mean don't locate a phone tower within 3.5 metres of residential backyards. I mean, couldn't be in plainer language except me saying it like that. I fail to see how anyone writing these rules that I've just cited would interpret them differently to the City of Prospect, to its elected members, or to any of the representatives who are, many of them are here tonight. All of the local amenity which we're seeking to protect is described, it's carefully defined in the code, and this proposal seeks to ignore it. We oppose it as a council for all these very strong reasons, all the while mindful that many better locations are available. It's the right infrastructure in very much the wrong location. It's a location that's non-compliant, it's offensive, and it's high impact. And in short, and at risk of paraphrasing the views of the elected representatives of this city, this location stinks. Thank you.
Thank you. Any questions of David? No. Thank you. Right. Karen Pepe.
I have prepared something that I'm going to read from. I'm representing other applicants that have put forward submissions. My daughter Helen Petros from 70 Ballville Street, and she did email you, Scott, to let you know that she wanted me to represent her. Kira Crompton from 29 College Avenue. I'm in this, I may go over 5 minutes, but I'm not reiterating different things from different people, but I am highlighting points that were raised in all of our submissions. So I'm the owner of the property at 31 College Avenue. My family were not aware of this proposal at 84 Maynooth Road until accidentally stumbling upon the application after it went to CAT in January. And boy, was I surprised. I'm going to address the contravenes the Planning and Design Code as stated in our submissions and further supported by Council's planning consultant, Brendan Fuster. There is a tower located directly adjacent to the residential zone. Moving the 30-metre tower by 1 metre is not going to have any less impact to residents living in the area, particularly to Jodie and her partner that live at number 43. There is no separation, as well as the house at 41. Can you imagine stepping directly out from the front rear door to look directly at the ugly tower? Our other residents living on the eastern side are very close by, and they're also impacted by the Telstra tower, which is directly adjacent their backyards. So now they'll be impacted by a second tower. Planting 4 pencil pines will not diminish the visual impact at all to residents in the area. Where the tower is located, it's adjacent to all the rear boundaries on the western side. One of them is actually my property. I will be able to see the pole with the antenna from my rear yard. This is an area that me and my family should be able to enjoy, not look at an ugly tower every time I come into my yard or be a topic of discussion when having family or friends over. That's not why I moved to the area. Unlike the residents, Service Stream did not provide any pictures of a superimposed monopole in the original application, nor in their written response. This would have shown the extent of the impact that the 30-metre pole will have on residents living in the sensitive residential zone from their front and rear boundaries. The photos they did take did not provide the exact location or angle on where the photos were taken. The photos they provided in the report clearly demonstrate the existing trees stand less than 30 metres and thus will not have the capability to effectively screen a 30-metre pole. The photo taken by Council's planning consultant on Prospect Terrace showed the location of the tower. This can be clearly seen over 700 metres, 700. I'd just like to reiterate that again. Imagine being located closer or being adjacent to the tower as Jodie is. I don't think there is anyone in this room that would find this acceptable. The consultant also showed a photo taken on the other side of the main North Road, which highlighted the impact to the landscape. The proposed Optus Vodafone tower is also significantly taller. My submission showed a superimposed photo which clearly states the extent of having 2 towers on the landscape and the residents living in the area. My submission was quite extensive and showed quite a lot of photos, if you were able to look at them. Residents live here every day, every night. They'll look at this from their homes, their front yards, rear yards, rooms in their homes. This is definitely not a minimising impact at all. Service Stream also mentioned that the subject land is not visually appealing and is devoid of vegetation, with the majority of the land used as a car park and vehicle manoeuvring. I forget to mention that this area is fully fenced. It is unseen by residents from their yards. I certainly can't see it. There is no direct oversight and it's generally accepted. And we accept that there's commercial businesses along this strip with car parks, not a 30-metre tower. Surface Stream state on page 342 and in its response that a 30-metre pole is not designed to minimise its visual impact on the surrounding area. Not quite sure how they can make that statement, which is very incorrect. They have not minimised the impact at all to residents living within the area. Moving it 1 metre and putting up some pencil pines does not minimise the impact. I'd like to address the 2 towers. Many of the representatives live closely to the proposed development and the current Telstra tower. I personally bought knowing there was a Telstra tower there. Residents do accept that to have coverage, there's a need to have towers. But to have 2 towers located so close to each other is really unacceptable. It'll be like having twin towers and will have a significant visual impact to the residents there. The residents of College, Orville and Costa will be significantly impacted by having 2 towers located so closely to each other and the sensitive residential zone. This area is known for its character homes, its leafy suburb and historic areas, as pointed out by the Council's planning consultant. The Service Stream report also makes no mention of the adverse visual impact that their proposed 30-metre monopole will have combined with the existing Telstra on the sensitive residential zone. So having 2 towers located so closely to each other will have a proliferation of telecommunication facilities in the area, which contravenes section 6.1 of the Planning and Design Code, especially where there are alternative sites that can be investigated. I and my family will be able to see both towers from our home. Alternative sites. Service Stream state there's no low impact options, but as our submission states, there are alternative sites that can be considered. My husband Enzo will go into more detail about that. But Service Stream's application submission has incorrect information or assessments that have been made, which are also incorrect. There are sites that are suitable, where they have not made any comment at all, nor have owners been contacted, and my husband will go into detail about that. Their comments need to be further scrutinised rather than just accepting what's been said as to why they aren't suitable. Council's planning consultant does state on page 101 that opportunities do exist for the proposed facility to be located further away from the boundary of the adjacent residential area. These require more than a desktop investigation. Their consultant should be going on site, having a thorough look around, taking pictures, investigate ownership and speak with the owners of these properties, not just send letters hoping that they'll respond. They mention that many sites don't meet car park requirements, but the loss of 2 car parks is minimal if the site considered is to be a better site away from this sensitive residential zone. Any site is considered better if the distance is further away from a sensitive residential zone. Sites should be considered where a tower could be located closer to the main road. As stated in my submission, Mainland Road is a primary arterial road with 2 lanes in each direction. Cars travelling down this busy road are unlikely to see and pay too much attention to a 30-metre monopole, and this should not be the main driver for discounting other sites. Drivers are concentrating on the road. There's a mixed match of commercial buildings, colour, age, quality. On the other hand, residents living in these homes will see this tower from their homes and rear yards on a daily basis. Examples of other sites where towers are located very close to main roads is contained within my submission. There are sites recommended for consideration, but none of which are considered to have tight access and manoeuvring. 83 Mainland Road is likely to be accessed by going straight in and out, as does number 85. 83 has no adjoining residential, and there is a willing owner there. Surface streams state that it is not safe to reverse onto the arterial road. The major impact will be the installation, and this can be managed appropriately. I personally deal with telecommunication leases on council land. I work for another council. Majority of any major works is completed after hours on the weekends to minimise disruption, and they generally give notice when they need to come on site. So any access issues can be worked through well in advance. When going down Mainland Road just the other day, on multiple occasions, I see semi-trailers offloading cars with not too many issues in which they appropriately manage. Any access works should be done in times which has less impact. You don't do it in peak hour traffic. You may do it in the early hours of the morning or later at night. Any site chosen should have these considerations, even on College Avenue. My submission also gave examples of where there are towers located close to main roads that have tight access and very difficult in manoeuvring. They can make it work if they're motivated to do so. Unfortunately, they've chosen this site and they're not prepared to look at any other sites. You can see that in their submission. We are also concerned about the noise, in particular, Jodie. They talk about the outdoor unit. They are going to move it, but one of the residents there from number 44 says she can hear noises coming from the Telstra site. She thinks generators are there, and we've brought generators up in our submission as well. The outdoor units will contain air conditioning units, which are required to operate to keep the infrastructure contained in the equipment cabinets cool. In warm conditions, the air conditioning units will be running 24 hours a day to ensure that the electronic equipment does not overheat and fail. If the electronic equipment overheats, it may fail and effectively turn off the transmission capabilities of the antennas on top of the pole. The effect of this is that the Optus customers benefiting from the proposed tower will have no service until the Optus technicians can restore transmission. And they also talked about generators. So there will be generators that could potentially be running more than for 1 or 2 hours.
Karen, have you got much more to go?
No, actually, half a page. The proposed plans nor the service stream report document the actual number of air conditioning units contained within the outdoor units. As mentioned above, in warm conditions, the units will be running consistently until cooler conditions prevail. Therefore, having air conditioning units running will create persistent noise disturbance that will diminish the quiet enjoyment of the occupants at 43. This, as I said, this was reiterated by the resident at 44 about the constant noise at night and described it as generators. Optus have not properly addressed the impact of noise to residents. So thank you for allowing me to address the panel this evening, and I'd just like to finish by adding that the residents should be able to continue to enjoy the day-to-day surrounds of their neighbourhood, not look at 2 mobile phone towers. Myself and other residents have talked about the visual impact, alternative sites, and that should be considered. The impact of noise and the impact of the noise, and gave some good examples of other towers located in tight locations as well as being close to the main road. Surely this is better than being directly adjacent residential homes. Me and other residents that I am presenting today are requesting that this proposal not be approved by CAB. Thank you.
Any questions of Karen? No? Okay, thank you. Enzo, you're there?
Thank you for your time today. I'm the owner of 31 College Avenue Prospect. I'll also be representing Ryan Pepe and Han Nguyen, who's the landowner of 33 College Avenue. We all oppose the Optus proposal to install a 30-metre monopole in the rear yard of 84 Main North Road Prospect.
Now, you're going to talk mainly about alternative sites, are you?
So just in terms of that, so Optus claim there are no allotments in the search area that do not abut a residential zone. The statement's inaccurate. We've provided a number of alternative sites within our proposals, which propose search areas that do not abut residential zones. It's clear from our research and discussing the matter with landowners of alternative sites that Optus had not contacted them or been to site to inspect their properties. Optus had not made any realistic attempt to research other sites, suitability for the proposed facility, including sites that do not abut a residential zone. Alternative sites have been nominated, are also further away from the sensitive residential zone, which is superior than the Optus proposal, which is 1 metre away from the boundary fence of a residential dwelling. These alternative sites have far less visual impact to sensitive residential zone. 83 Main North Road. As my wife mentioned, Optus claimed that it's not safe to access the site during construction. As she mentioned, this can be alleviated with appropriate traffic control. We've demonstrated in our responses that Optus have previously installed monopoles in areas that had very limited access and egress, and manoeuvring the site itself was extremely difficult. Therefore, safe construction and ongoing maintenance of the site is achievable. It's just more of a want than more of a need. So they also claim there's not enough car park spaces. However, this claim is contradicted by their own car park assessment, which was included in their proposal dated 29th of March 2022, that states that this site does meet the on-site car parking guidelines. Therefore, both claims should be dispelled and the site should be considered as a viable alternative site for the proposal. 102 to 110 Main North Road. Optus claimed they contacted the landowner on the former radio rental site. However, when I contacted the landowner, they claimed that neither Optus nor any of their representatives had made contact with them previously. My contact with the landowner was after 7th July, therefore this contradicts their statements and their submissions. 105 Main North Road and 3 Edward Street. As demonstrated in my response, this site is superior to 84 Main North Road, as place a monopole in 105 Main North Road result in development abutting 3 Edward Street, which is a zoned urban corridor, as opposed to Optus proposal, which directly abuts a sensitive residential zone. Therefore, the site, which has a willing landowner, should be considered as a viable alternative site for the proposal. 138 Main North Road. As mentioned in my response, a dwelling at 138 Main North Road is not a residential dwelling, as mentioned in the Optus submission. The occupant is using the site for business purposes. He does pool table repairs. I met the gentleman. He showed me the business. I spoke to the landowner, and they are not being contacted by Optus or any of their representatives. This property is also zoned urban corridor business, as opposed to the Optus facility, which again abuts a sensitive residential zone. Therefore, this site should be considered as a viable alternative site. 87 to 93 Main North Road. Optus response makes no mention of locating the tower on top of the Office Works building. As mentioned in our response, this site is very comparable in height to the former radio rental site. Also, it's approximately 80 metres from that ex-site. So it meets their RF guideline search criteria as they propose, therefore making this site option a superior to 84 Main North Road, which is 280 metres away and outside of their search zone. 61 to 75 Main North Road. This is a car park in the rear of a property that provides sufficient space for a mobile phone facility. The site does not abut a sensitive residential zone. Access to the site is achievable via a side street that will provide safe access for construction and for their maintenance teams ongoing. 7781 May North Road. Site exceeds on-site car park guidelines and does not a part of sensitive zone. Access site is through a side street that will provide safe access to construction. 77 Gloucester Street. In the service stream report dated 29th March, they made reference to 77 Gloucester Street as an alternative site. They make a claim that the landowner withdrew their interest. We have spoken to the owner and the building of the apartments. The statement fails to mention that negotiations were very well advanced, whereby the owner had installed at their own cost reinforcing the structure to accommodate the proposed Optus facility. The facility installation did not proceed due to several unreasonable conditions that were introduced by Optus at a later stage. According to the owner, Optus became extremely difficult to negotiate with, and as a result, the owner had no alternative but to cease negotiations to install the facility. Lack of transparency in RF requirements. This is another issue that I did raise in my submission. So Optus, again, the Optus response does not address this concern. The response does not provide RF data criteria guidelines that we use to select 84 May North Road as the preferred site. Originally, Optus required the site to be within 200 metres of their previous facility at the former Radio Rental site. However, as mentioned, 84 May North Road is 280 metres from the site, therefore is actually outside of their preferred RF site search. The selection of 84 May North Road contradicts the statements Optus have previously made regarding the RF guidelines when selecting a suitable site. The list of sites, if the alternate sites containing the response were previously provided, that is, it's not RF guidelines and data information we were requesting. Optus should be required to disclose RF information to the public so that CAP can make an informed decision regarding the approval of their proposal. Noise impact, my wife's gone through that in great depth, so I don't need to go there any further. I can say that, yes, they will make a lot of noise, and in warmer weather, they'll be running 24/7. In regards to the power supply, the proposed Optus installation plans make note that a power supply to the installation still requires SAPM confirmation regarding the amount of power supply and size of the power cables required. The notes also state that the power supply upgrade may be required to accommodate the Optus installation and that the power upgrade application will be submitted in phase 2. On this basis, Optus have not fully disclosed full details on the amount of power required to power the base station and if a generator is required to supply power on a full-time basis. If the existing power supply is not adequate or in cases of intermittent or prolonged power failure incidents. Optus has confirmed that they will not know if the tower will require a generator to supply power to the facility or if they can rely on the existing power feed from the street. As acknowledged in previous Optus reports, a generator located close to a sensitive residential zone will cause unnecessary noise disturbance to the occupants of 43 College Avenue and the neighbouring residential dwellings. Optus has a resource to predetermine if they need a full-time generator prior to the SAPN inspection. CAP should request confirmation from SAPN that the existing power feed from the street will be sufficient to power the facility without the use of the generator prior to approval being provided. Visual impact. Service stream report claims that proposed 30-metre monopole will be screened by the trees along College Avenue, travelling eastbound to May North Road. The photos they provide in the report clearly demonstrate the existing trees stand far less than the 30 metres that the pole will present, thus will not have the capability to effectively screen the pole out. The photographs they provide do not contain a superimposed image of the visual impact that the monopole will have on the vista. The report has not fully considered the negative visual impact that it will have also to the residents on a permanent basis and the traffic travelling east along College Avenue to Costa and Bourville.
And so these are points that have already been clearly mentioned, particularly by Karen and others. Is there anything, given that your time was up quite a while ago, that you haven't made a point of that hasn't been expressed to date?
Sure. Car park guidelines. We know that the service stream first presented the car park assessment in January 22. It listed Crowe's as a tenant with a preferred site at 84 May North Road. In April 22, the upstairs tenancy was leased to a travel agent. We note that in the most recent edition of the car park assessment that the new tenant was not added to the Crowe's as a tenant listing. When we contacted the leasing agent in early May 22, he was unaware of the proposed development and had not advised the new tenant of the development. still not sure today whether they still even know. As there is no notation for the 84 Main North Road, it appears that the assessment has not been calculated on the basis of multiple tenants. We request that Service Stream disclose the calculations that they use to determine the car parking requirement serviced by 84 Main North Road meets the car parking guidelines. I think the overshadowing has been covered by David. I want to go through that. The contravening the planning code, I'll quickly go through that.
We've heard that as well by numerous people.
All right, just to quickly say that they make mention that the equipment cabinet won't be visible by the street. The proposed height of the equipment cabinet is 2.2 metres high. The existing boundary fence for College Avenue and the average utility vehicle, I make note of Ford Ranger, for instance, is only 1.7 metres in height. Therefore, during the day, anyone walking past and driving past will notice the equipment cabinet. It will be visible so long as those fences are open. I think everything else has been pretty much covered.
Enzo, let's leave it there. I think.
So, just in closing, we respectfully request that CAP take serious consideration to the report provided by Brenton Fuster, acting as the Council's appointed consultant, and the submissions lodged by myself and other residents of the area, all opposing the proposed Optus mobile facility development. Trust that there are sufficient grounds presented in our submissions for CAP to refuse the development application.
Thank you.
Thank you for your time.
Any questions of Enzo? No? Thank you. Lucy Hood? No? Okay. Lucy Hood? No? Okay. Brian, you're next. Are you going to,
Mr. Chairman, I
condense your presentation to one or two?
you long. I'm representing two of them, Mr. Brad Milburn and his company. They're virtually, apart from the fact that Mr. Milburn actually lives there, the representations that I make now will be pretty common to both, so I won't take up time. I do have Phil Brunning here from a planning point of view.
Phil, do you want to come forward?
He'll be available to answer any questions of a planning nature. Can I start, Mr. Chairman, by referring to the planners, your administration's report at page 90. There's a mention of the current appeal that exists in the Supreme Court. That's an appeal by my client, Mr. Milburn, and it is against the effectively against the compromise proposal that this panel apparently approved as part of the ERD court proceedings. The appeal is against the refusal to join us as a party, and if we are successful in that appeal, then that compromise proposal will be put at naught. I'm hoping. So therefore, it's my submission that this panel should not be in any way influenced or take into account that fact. Indeed, if you were to take it into account, I would respectfully suggest you would err, because you then put yourself in a conflict of interest position, having approved a compromise proposal which is identical to the one that you've now got before you. And therefore, it is important that you look at this proposal as a totally different and a new proposal, which it is. It's highly unusual, as was pointed out by Mr. Lachlan, that the council, which is the representative body of this area, should oppose this as a constituent body to oppose the development, sufficient to come and make representations in support of that opposition. What I would like to do is not go over it. You heard all the information. You've had all the planning evidence given by the representatives this afternoon, this evening. I've heard all of that, and I'm not going to go over that again. But what I would like to do is to just make some observations about that evidence that you've heard. It is, you're faced with a situation today of an application which on every single point flies in the face of the planning and design code. For example, the zone in which it is proposed is the business zone, the urban corridor business zone. That is the one zone that does not have any make any reference to a development of this kind. Therefore, you're looking at it as if on the basis that on its merits. However, it's interesting that the code does refer specifically to developments of this kind in other zones. For example, the employment zone, the bulk handling zone, the whole series of zones in which a development of this kind appears as a not necessarily an envisaged development, but as a development which is specifically referred to. And in that context, it requires a 50-meter setback from an adjacent zone. Now, it is inconceivable that this panel could permit this development, which flies in the face of that 50-meter adjacent zone requirement, where the same requirement is specifically referred to in a zone where this sort of development is contemplated or might be contemplated. So that is so fundamental in this respect that it's inconceivable how this panel can even consider approving that, because it just flies in the face of that. But then if you look at all the other provisions that it flies in the face of, there are numerous ones, and I won't go through them because your planner, who is engaged to give you a report on this, carefully identifies each of those provisions with which this conflicts. The points that the applicant makes, and this I'm looking at his applicant's response in the report, deal with none of those major issues. There is no mention in their response about why you should have it 7 meters away from a residential house. Indeed, in one case, I think it's 3 meters away from a residential house. There's no reference to the points, the response to the representations. They talk about the design being amended to include relocation of the equipment units. Well, so be it. Is a replacement of the now decommissioned facility wholly irrelevant? Why does that influence whether this should be approved, contrary to the provision? It needs to be as near as possible to the facility it replaces. It isn't. It isn't as near as possible from what I can gather. But in any event, there's another pole 74 meters away. Now, one has to ask the question, what on earth is going on here? The code, I'm not talking about the planning and design code, this is the communications code, contemplates that there be this sort of provision made in an area, but not where it is capable of being co-located, which all of the evidence here would suggest that it can be. And the statement, a bold statement that by the applicants, which says in this case there are no low impact options, including co-location on existing telecommunication structures available. Well, that's just a statement which has been disposed of by all of those representations. And Mr. Chairman and the panel, it is not the role of the representors to go to this enormous trouble that they have done and identify alternate sites, which they have done. That onus is on the developer. But here you have a case where the representors have effectively disposed of any argument that there are no alternative sites available. And they've done it in a very detailed way. And it's interesting, Mr. Chairman, that they've put in so much work to identify what is a very important criteria, which the applicant simply does not deal with. So, Mr. Chairman, in my respectful submission, there is nothing at all which would justify this panel approving this application, having regard to all you have heard this evening. And I'm happy to answer any questions, that particularly Mr. Bunning here can answer any questions which are entirely within his expertise.
Thank you, Brian. Brian, you almost inferred that this proposal was seriously at variance.
Yeah, very close to suggesting that, Mr. Chairman.
So you're not suggesting it, or are you?
We know
you're sitting on the fence.
Is from a point of view of a planning authority like this to conclude that it is seriously at variance. I'm not in a position to put that argument on the basis that it is seriously at variance, but I can only go so far as to say it's very close to that. But that will not preclude me, should the need arise later, of arguing that it is seriously at variance.
In any event, I don't think you need to go that far. It falls over before the issue of serious variance is even raised.
Well, shouldn't it be raised first before you go the other way? Yes, let's not get into that. Would you agree, either of you, that the code seems to place less emphasis on recognising essential infrastructure? Is that a fair comment, Phil?
Well, I think consistent with federal legislation, it gives a bias in favour of essential infrastructure to an extent, but it's not carte blanche.
As much as it was in the development plan.
Well, and more so because the code is quite specific in the way in which it's structured and directs these facilities to particular zones where they're specifically spoken of and provided for. In this case, that's not the case. And in those cases where facilities of this nature are specifically provided for, there's a key criteria that Brian's mentioned, and that is that they're not to be closer than 50 metres to a neighbourhood type zone. Now, even in those situations, they have to be removed from sensitive uses. We have a situation here where it's in a zone which is effectively silent, and to the extent that it can be considered in this zone, doesn't meet a similar threshold test. Why would it be any more appropriate to locate a facility close to?
I think we're getting away from the question that I asked.
Your question, Mr. Chairman, speaking for myself, I would suggest that the new code has less, speaks less to the need issue, because, with respect, I think it may now resort to the Commonwealth Code and the requirements under the federal legislation in that regard. So there's no need, sorry, for that further reference as there was in the Development Act. Because if you look at the history, the Development Act came, it was in bits and pieces, and the federal code came in, and that's where these conflicts arise. Now I think it's quite clear.
Any questions, members? No? Okay, thank you. Thank you, Mr. Chairman. Right, now, have we got enough chairs for the applicant?
We bring some chairs forward.
Well, bring your own chairs forward by all means, rather than removing other people. Now, Lynette, you've been before us before. So, thanks. That's everyone else.
My name's James Hilditch from Hilditch Lawyers. I'm a planning lawyer. I act for Optus, and my clients requested me to assist it to respond to these representations together with Ms. Brandwood from Service Stream. I have Mr. Howard Gain from Optus with me to my right, Mr. Thomas Gallos to my far left, who is an expert RF engineer for Optus. So you have anyone here that you might need to ask questions in terms of the alternate site selection process and anything in relation to the RF engineering aspect of all of this. Whenever you hear a planning argument, it's very important to follow it through to its logical conclusion, and that enables you to test whether or not it makes sense. The reality is that our telecommunications network comprises essential infrastructure, and from time to time it's going to need to be replaced. And this is one of those very examples where we have a replacement facility which is absolutely required to provide a service, an ongoing expected essential service to customers. And I'm not going on, well, the obvious observation will be that most of those who made a representation tonight will rely on mobile phones, and I expect all of you will as well. There's no argument there that they're essential. It can't be right that if the catchment where the replacement's required is not in one of the zones where telecommunications facilities are envisaged, and I think the employment zone has been used as an example, it just can't be right that, well, sorry, you can't replace your facility there and you can't supplement your network there. You're going to have to go to one of those zones in the code where it's envisaged. Because the answer then is to all of those customers in the relevant catchment, sorry, you're not going to be able to rely on a mobile phone. You have to presumably get a landline back, I suppose. That would be one answer. It can't be right. The other difficulty also, this idea that there should be a 50-metre separation distance, I'm not sure where that comes from. I had a look at the employment zone and to take an example, and in that zone we can see telecommunication facilities envisaged, and then the performance outcome is that telecommunication facilities should be located to mitigate impacts on visual amenity in residential areas. That's the general expectation that the carriers have to work to mitigate visual amenity impacts. Now, the right-hand column of the code, which hopefully you're all now familiar with, is the DTS and the DPF, deemed to satisfy the design performance feature. That is where the 50 metres comes from. So if you're in the employment zone and you want to erect a monopole up to 30 metres and you can separate it 50 metres from a residential zone, you can say, well, we're deemed to satisfy development. It does not say that to have a monopole in the employment zone, it has to achieve a 50-metre minimum separation. So what if, for example, you're in a classic situation like we're dealing with here in a long strip zone and you don't have properties that are 50 metres deep? Again, does that mean that you can't provide the service? And I've read a concern in the recommendation about building height and the suggestion that another problem with this development is that it exceeds the 15-metre building height. It's double the height. Well, the code defines building height, and the definition of building height specifically excludes telecommunication facilities and monopoles. So it doesn't take the matter anywhere or assist you to look at building height and look at those provisions and then try and apply them to a monopole when the authors of the code have told you these provisions don't apply. So I don't, with the greatest of respect, agree that all of the issues have been dealt with in the correct way. I know my friend Mr Hayes, who I have enormous respect for, and he's well aware of that, but he referred to the representors as the planning evidence which they gave. I don't think he meant to say that, but just to be clear, I'm not here to criticise any of the representors. They have obviously expressed genuinely held views. There can be no question about that. But ultimately, they are personal opinions and they're entitled to express them. But I have on either side of me the experts who are dealing with this matter. And ultimately, what is required is a replacement facility in this catchment. Can I just finally deal with this alternate site issue? I've dealt with a number of these proposals before, including before the courts, and it is quite common and understandable for representors to point to the other site across the road or down the street. On many occasions, it will be possible to do that. What has to be identified, though, once a site is nominated as the outcome that a carrier seeks approval for, the question then is there an alternate site which meets the technical requirements of the carrier and which is available and which is obviously better? That enables you to test the visual impact question. And so if you can be satisfied that there is an alternate site which is available that meets the technical requirements and is obviously better, those are the sites which you will scrutinise to consider whether or not visual impact has been minimised. It's not enough to say there's another one over there, because quite often all you'll end up doing is shifting to another site and you'll hear all the same arguments from a different group of people. And that's not what the code or our system envisages. So it's not your role to ask, is there an alternate site and has it been looked at? The question is, has anyone put forward an obviously better alternative meeting technical requirements in a better way? And we say, no, there's not. And that's why my client has landed on this site. Again, they're all here to answer any questions. Thank you.
Thank you. Do you want to at least address the proximity of the tower? It might be in the right zone, but it's hard up against a residential area. Is there anything you want to say about that?
I think Ms. Brownwood dealt with that, and it is a hard and difficult reality that when you are dealing with a very large zone and a very large character overlay, like the one immediately next door, you cannot expect the same character and amenity at the interface with the business zone as you could at the heart of that zone. That's the short answer to the difficulty. There will always be interface issues to manage. I don't understand there to be any great dispute that this zone is a logical place to look to for a solution for the tower. The question is it too close? But the problem is when you are dealing with a strip zone, quite often on a main road like this, quite often you'll find that the focus of activity, of commercial activity, is at the front of the site. And it's either going to be the display areas for the car yards or the office front or the shop front and all the related advertising. And so this site's a classic example where you have a landowner who is prepared to accommodate the facility, but down the back of the site where it's out of the way of deliveries, car manoeuvring, all of those kinds of things. So that is the only, as I understand it, area on this site where this landowner is prepared for the facility to go. And that's not surprising. So that's, in terms of this site, that is the best and only alternative for the pole. So that's the answer to that issue.
And the question of the alternative site in terms of the cemetery or joining the cemetery?
I think the short answer is it's a state heritage place. It's a state heritage place. But I'll allow Ms. Brownwood perhaps to comment.
So, Chairman, are you speaking within the cemetery or adjacent?
No, adjacent. Where
the properties adjacent to the cemetery were looked at, and they were not. The landowner was not prepared to enter into any discussions with Optus. They were approached twice, to my knowledge, in the original search for this facility. Their car parking is inadequate already as well. Of course, we would have looked, the first properties that any team that goes out to do site selection looks at is adjacent, a better use. No one wants to be next to a dwelling wherever that is possible to avoid. In this case, there were no properties adjacent, commercial properties or non-residential land uses where we could get a landowner interested.
Sorry. Other questions?
Rob, just a quick question. What comment have you with the site at Crowey's being further than 200 metres outside of the previous radio rental site?
Thomas?
So basically, design briefs brought up, provided by Optus to Service Stream in this case, where we have a target polygon that we need to cover, which is bounded by Tennyson Street to the south, Wilcox Avenue to the north, Prospect Terrace to the west, and then Howard Street to the east. And to basically cover that area, it needs to be covered within by a site along the strip along Main North Road. There is a search polygon that's been provided, which I think was in one of the documents from Service Stream, which shows the actual. So page 128. So that there is basically the search polygon that Optus has provided in order to achieve the objective of the target area by those streets that I called out earlier. So it needs to be within this vicinity or within this polygon or as close to that polygon to actually achieve that. Pushing a site further south or further north will basically impact that ability to actually achieve the objectives to provide the L1800, the 1800 megahertz band in building levels at NEC 90, which is basically the planning rules that we use based on, from atoll predictions. So that's the planning database that's used, which when the coverage maps go out to the market or on the website, that's basically what's provided. So they are as close to accurate as they possibly can, because from the perspective of that. So that's basically what we would choose it for.
Possibly if I can just expand on this slightly. I'm not sure whether the 200 metres comes from. I like, but perhaps others could comment. But I guess the important point to make is that when we're trying to secure a site, we're balancing all sorts of considerations, and one of the most fundamental ones is a site where a landlord is willing to enter into a commercial relationship with us on our selfish terms. And the radio engineers will often say we want a site in location X, and we, the site acquisition people, come back and say, look, we can't give you X, but we can give you X minus. Is that sufficient? So I've just said I don't know where this 200 metres comes from, but it isn't always possible to deliver the perfect. And so we'll come up with as close to perfect as we can. So assuming the 200 metres has any sort of meaning, and we're slightly outside that, it's only because we're on Service Stream. Ms. Brownwood's colleagues were unable to secure a site that was within that 200 metres. But as I said, I still don't even know where that came from.
The 200 metres is an approximate, and I think that was the one word prior to the highlighted 200 metres that was left off the yellow highlight in the previous representative. It's just an approximate to try and stay as close to the target area as you can when you're searching. There are a number of parameters, a number of considerations, such as town planning is paramount, property acquisition, the ability to have a landowner interested in the site. It must still not digress from the network needs of the site. Otherwise, there's just no point in it. And to try and stay as near to power and access as we can, so that we can design and build something that's not going to be, that is viable, that's not uneconomically viable.
Over a year ago, it was said, while it was still, radio editors were still there, that it was urgent that this be moved as quickly as possible. So now that radio rentals has been demolished, how do these people get in coverage at the moment? Optus customers?
Basically serving from a larger distance on the low band, which is very limited in capacity. There's a lot of loss in low band in building coverage. So on street, you might be okay. But even then, as soon as you sort of like veer away into the streets, into the clutter, you're virtually losing your coverage. So there's deficiencies in coverage, service levels, increased drop rates, much lower throughput. So people are going to be struggling to get 2 or 3 megabits per second. So, when people have a service that they've paid for and you take a site away, they basically start complaining. So they'll either walk out the door, or basically Optus provides a free service until a service is available in the area, but you can't actually cater for the demand and the increase, and especially from a wireless broadband perspective in building, you can't provide that from 2 or 3 kilometres away.
There's obviously multiple ways you can solve issues in your zone. But one of the solutions, so for example, if you could not get this site approved through any regulatory process, ERDs, all that sort of stuff, is there another solution? Is there a whole lot of lower impact solutions within that zone that could resolve it?
We did look at small cells throughout the area, particularly along Main North Road, and I don't know if you understand the small cell.
Yeah, I do.
There was a review to see if maybe small cells might be adequate for this, but they're not going to give the capacity and the coverage into the area. They're not just trying to cover within that red rectangle, they're trying to cover a much larger area, and to get into that larger area to give capacity in building, people working from home, people studying, they're forced to work from home quite often, medical access. To get into buildings, you won't get that from small cells on Main North Road.
As an example, so at the moment you're talking about a replacement of a monopole, okay? As an example, could 3 rooftop facilities in that same zone area achieve your RF objectives?
Would need to be reviewed, but looking at surroundings, yeah, they'll be very low. So you're only talking, what, 10, 12 metres, 13 metres at max. So
you're talking about a main road there, and there's
potentially wait till
a lot of
essential
story though, aren't they?
So essentially, you've got where you've sited today. You've basically got a site that's right against the residential property. It's a very sensitive boundary. I mean, the simple thing of it being closer to the building would have been better. That's just one. But
we would love that.
You take that further, and then essentially, unless your alternatives that you've looked at has also looked at a multiple rooftop or multiple low impact, a multiple solution.
Haven't with that is they're all going to be
all the solutions.
All be low sites, so therefore they're going to be amongst the clutter and the buildings. So they're still going to be positioned on Main North Road, but they're not going to be able to sort of serve east or west from the site, which is what is also required. We're not just covering Main North Road, we're covering west out to Prospect Terrace and then to the east out to Howard Street. So we're talking about an expanse residential area to provide in building coverage from a rooftop site, which is going to be blocked by clutter. The houses in the area are more solid, so therefore the penetration losses are high.
As I understand, you're trying to resolve it by one facility doing all of that, whereas essentially you still possibly, if that facility wasn't available, that site wasn't available, you would achieve it through a different means.
Main North Road we will, but I can't see how we're going to build into the residential area.
Multiple facilities.
Okay, we're starting to just debate rather than answer questions and stuff.
I'll state that it has to be viable, an economically viable, a cost-effective solution. So I don't think having 3 low-impact facilities along Main North Road to cover that commercial area and multiple sites in the residential area is going to be a cost-effective alternative. So that would not meet the requirements under the Telecommunications Act either.
Any other separate questions? Right.
Just got 2 if I may, Chair. One for James. And you've partly addressed my question, but just about this alternate location option, and certainly contextually from a background perspective, it was a big focus because the development plan specifically referenced looking at alternative sites, whereas the code no longer does that specifically. So just wanted to make sure that I'm absolutely clear it is appropriate for the panel to consider alternate sites. If and hopefully I'm not misquoting you, if it's clear that there are other obvious sites that are better in relation to minimising impacts on amenity and so forth. And I only ask that because certainly our previous assessment, again, this is a new application, but it was under the old development plan, and that's where it was referencing looking at alternative sites as part of that assessment.
Well, the development plan dealt with the concept of minimising visual impact, and out of that and the related policy stemmed a whole bunch of case law going to our full court, our full Supreme Court and the High Court. None of that's been referred to in the report. You don't have any discussion on it. Ms. Brownwood has referred to it in her response, but the idea there was that one of the ways that you deal with the concept of, see, the difficulty with the structures are they having a visual impact, and that's a given in the planning system. So there's a danger in looking to in looking to minimise or avoid visual impact in an unrealistic way, because if you do that, you'll end up refusing approval for essential infrastructure. The other, it seems to me, more logical and achievable way of going about it is to consider whether this is the site that's been identified has been identified through that process that's on the screen up there, all of those alternate sites, for example, being looked at and considered within a catchment. And nothing has changed about that in terms of the way in which my client has gone looking at this site under the new code as opposed to the old development plan. And indeed, this is you'll be aware, this is a continuation of a long ongoing process. So I think the courts have suggested it's perfectly appropriate to look at alternate sites, but I come back to the point that if there are 3 equivalent alternate sites and you keep pushing the problem elsewhere, you'll never get to the answer. And often that will be the case. So the question is, once you land on a site, is there an obviously better one? And if not, there's the answer.
Okay. Excellent, thank you. And that I think leads to my next question, probably for Lynette. In your analysis of alternate sites, of which are on the screen, there are obviously a couple there whereby, and my interpretation of your report is, yes, they may be appropriate, but they're potentially short on car parking as it currently stands. So just so that I'm 100% clear, or the panel is it safe to say that in some of those circumstances, and for example, office works as one example, it's possible that a deal could have been reached with the owner, but the issue is, from a planning perspective, if you locate the tower in that location, you would lose car parking spaces, and the site is already deficient on car parking.
Well, specifically for the office work site, they would not.
They won't. Okay.
I believe that that a loss of car parking, even if they were under on that particular allotment, would still be fine. Would still have a better visual outcome.
Yep.
I think Rob is asking, if you don't consider car parking numbers and the like, would some of those alternative sites been acceptable to you? Rob, is that?
Yeah, that's correct. Yeah.
Thank you for explaining, Jim. Most of the allotments along there, and you'd have to be specific about one or another, and I have to get out Google Earth or Near Maps, but the majority, if not all of those, would have residential properties to the rear, either to the east or to the west. So we would come against the same problems again, just with another community.
I think it's probably, point taken, I think it's probably potentially being able to, some of those sites have car parks fronting Main North Road, so with buildings further to the rear, so potentially there might be the opportunity to maximise the separation distance from residential further, in this case, to the east. And I guess it was just me trying to understand some of those instances, well, are they options? But it's just that, there's a potential loss of car parking, because that is just basically an unbalanced assessment. It might well be that the amenity benefits outweigh the loss of car parking, as an example. In some instances where a monopole is forced to be
on a main arterial road. One would think that it may be better, but it's got a greater impact to so many more people. If we have some separation to the residential boundaries to the rear of these properties, either east or west, what distance separation do you think would minimize, would take away that visual impact? I don't believe that in this corridor there is such a thing where there's going to be no visual impact.
I would ask, would 50 metres be a detrimental impact to a point where the service is ineffective?
Sorry, is that
Would
to
50 metres in any direction have a detrimental impact on coverage?
location?
The location proposed, moving at 50 metres in any direction, would it have a significant
I
impact?
can answer that. Before I get to you, we did try to push this to other properties further to the south. It can't go any further south. They are at minimal threshold on the southern boundary of this. We were told not to push any further. It's a if we have to have it so. You're more technical.
No, that's right. So moving at 50 metres north isn't a problem, or 100 metres north, but bringing it south is where the issue lies, because you're pulling away outside the target, the search polygon, but then you're then going to like cause a detriment to the northern section of it. So you're not going to cover the target polygon to the levels that are required to meet the customer needs.
There seemed to be from the residents a push for 83 Main North Road, and that the owner was amenable. Do you want to add anything to any of that?
It's a dental clinic, I believe. It has 4 car parking spaces on the boundary to the cemetery. There's turning area in there. It's not easy turning area. I'm not talking from it, and I know that it was addressed and they're suspecting that construction can be done outside of ours. I totally agree. My reference to access and egress from that property is not about construction. That's a one-off. Maintenance is a very, inconsequential. It's maybe 3 or 4 times a year. It's the patients of the dental clinic trying to come in and out of that property through an extremely narrow driveway. It's just barely a card's width. I don't know if you can see. Yeah, you can see it on the screen now. It's a very narrow driveway, and to come in and out of that property from the rear you must manoeuvre in the rear car park. To have a pole in the back removing 2 of the car parks might be able to get away with that, but you'd have no manoeuvring for those people using the dental clinic, and they can't park on Main North Road to go and have a checkup or a filling. They need to park at the rear of the building. They may be very willing to have a site on that land, but I do not believe that it's something that we should consider. We can consider, because you would have to limit to 1 or 2 patients at a time. How do you do that? You can't have 2 vehicles crossing in this driveway. It's far too narrow.
That be the dental clinic's problem, though? What does it mean to you? It's the dental clinic's problem.
Well, it may be, but how is that not going to impact outside of the allotment? Isn't that our job, not to impact outside of the allotment?
It's your job to impact.
I think it comes back though to the role. I don't think the role of this panel is to look to solutions which aren't obviously better with reference to the code. And I think the point Ms. Bramwood is fairly making is that if the carrier lands on a site that has no prospect of approval because it blows out of the water the car parking requirements and provision, it's got nowhere to go. It's not asking that. So it's again, the question is this an available, technically feasible site that meets the needs and is the best available alternative, having regard to the code, car park requirements, all of those kinds of things. It would make no sense for my client to come before you before it has identified through a rigorous process, which it's gone through, what it believes to be the obvious, available, best alternative. And that's what it's done. It's now for you to assess that. But it's more than a function of people saying that side over there would be better because it's further away from me. It's understandable for people to encourage that outcome, but it doesn't take the debate anywhere.
respect.
Okay. Any other questions? Sorry, Will, did I give you enough opportunity? Yep. Okay. Thank you. Any questions of staff?
I guess I've probably got one question from me, Chair. Brendan, I think, so just on the back of the conversation that's been heard, I think, you know, in your view, I think the alternate site is probably a fairly critical thing to consider. What's your view? And obviously we've seen your recommendation, but is there, you know, on the back of that sort of, you know, the discussion, is it your view then that basically there is options for locating this in a better position that would have less impact on adjacent residential properties?
Definitely. I mean, as in my report, I took a fairly simplistic approach that in this location here, you have a zone that is X metres wide with numerous commercial properties and so on, car parks. There's plenty of land available in that zone, confined to the zone boundaries, where a facility of this nature could be located that's going to have a lesser impact. Simple as that.
So, Brendan, you're accepting that this zone should be capable of accommodating a tower, even though the code doesn't speak to it, but it's its proximity to the residential zone that is the issue for it. Is that in a nutshell?
In a way, what I'm saying is the code speaks to more suitable locations from a zone perspective, but this is a zone that contains commercial industrial uses, similar to some of those zones where facilities of this nature are envisaged to some extent. So, look, on that basis, it's probably a reasonable zone, provided the facility is sited in a better location. I mean, this is 3 metres from a boundary to a residential zone or type zone, with a character overlay as well. Yeah.
And with housing that meets that overlay's intentions.
Yes, definitely.
Okay. So where do you interpret the 50-metre setback? Where do you put the weight in terms of that, or don't you?
I mean, certainly give it weight. It's a guide. So what the DPF is essentially saying is you need reasonable separation in order to minimise impact. In this situation here, there is next to no separation whatsoever. So certainly in my mind, it's near impossible to say that they have minimised impact. It's 3 metres from a zone boundary.
Any other discussion, questions of Brent? No? Okay. I'll open up the discussion. Who wants to go first? One, you're looking as if you're
happy to. I'd probably support the officer's recommendation. I personally don't feel I actually have enough information on alternative solutions to actually make the decision that this is actually a suitable site. What is clear to me?
Let me ask a question then of you.
I'll just finish up. What's clear to me is it sits on the very boundary of a very sensitive residential zone. And if I was to ever say that's okay, I would want to know that was the only alternative location that could be achieved on the site. And I don't think I've got the information, which is almost the officer's actual report. The conclusion that it's a very big zone. There's plenty of alternatives that could achieve the goal. I just don't have the information.
My question of you and anybody else was that you seem to be putting some emphasis on alternative technology as opposed to alternative sites. And I'm not sure where that leaves us.
What I don't have is the alternatives that I don't actually have the information that says here are all these alternatives we could have selected from, whereas we've got just this one site. And what I'm saying is that with that one site, I don't know the answer to all these other alternatives that are in that zone, that whole big square that I was looking at, and there could be plenty of other alternatives. What I do know is this solution, this proposal, has a monopole on the back boundary of a residential zone, and it's a very sensitive residential zone. It's character zone, so I mean, we must all agree that that's a very sensitive boundary.
Yes.
Yeah. Therefore, is it the only solution? Well, I don't have the information, so I do think it needs to be proven properly, that is the only location.
Okay. Robin, do you want to?
Yeah, look, this is a terrific report, very comprehensive. Clearly, there's overwhelming opposition, and some of the reasons we've already said don't have any weight, like the public health, property values. We can't go into that. I think the two main things I picked up, I think, was the adverse effect on the visual amenity is so important, and secondly, the applicant's response that there's no viable, practical, better alternatives. I just don't believe that. I think our representations have been very impressive, and have done obviously a lot of homework into that situation. So I fully support the recommendation from Brendan that it be rejected.
Okay. Rob, do you want to go ahead?
Yeah, so I guess up front, I think point to note is that we are dealing with different policy from what we considered previously. And I think, thank you, Brendan, for pointing that out in your report as well. Urban corridor zone, I don't share the view that the zone isn't potentially appropriate for a telco facility. I think certainly, and as per the planner's report, the zone does contemplate businesses, and businesses need telco facilities as do residential properties. So, and there's clearly a demonstrated need in that locality for a telco facility. And it's also obvious that just because it's not listed as a contemplated use, it doesn't mean that it may not be appropriate when assessed on merit. So I do, there is obviously that weight or some level of weight or some guidance provided within the other zones around the 50-metre guideline, but definitely accept James Hilditch's views that that is obviously a DPF, but notwithstanding is a guide, and it does indicate that the greater separation is obviously something that can mitigate the impacts of telco infrastructure on residential properties. I do also accept the view, though, that, the urban, so if we accept that the facility needs to go somewhere in the urban corridor zone, that does pretty much just go along the main road, and you've got residential on either side. So I think we do need to exercise some caution in whatever we do tonight, because if an alternate site comes up, it's only fair to consider how that other person on the other side of the road, for example, may feel when the facility is then going near them. So I think it's really important, in my mind, when I've considered this, to be comfortable that there may be other sites that are better than this one and further away from what might be a residential property somewhere else when another site may come to us. So I think in that regard, I do believe that there may be some other alternative sites. I think certainly in the consultant's report, the applicant's consultant's report, there is potentially sites elsewhere that may be further away from residential properties, or that are. It's just a question as to whether or not the loss of car parking on a site where there might be already a shortfall of car parking is appropriate. Now that's an assessment that I guess needs to be done. And I think it's a question as to whether or not the preservation of the amenity at the expense of some more car parking is a preferred outcome, and that's a balanced assessment that we would need to take. I think given the size of this structure, I think there's potential for that to occur. So in other words, it might well be that a shortfall of car parking on the property, if it means you've got a greater separation from residential, is a better outcome. So I think in my mind, I think that is potentially an option. And on that basis, I don't support this application. I think there are potentially other sites that are better that need to be explored, even if it means potentially a shortfall of car parking.
Will?
I think it's probably a bit dangerous and risky to borrow policy from another zone and sort of plonk it in another one. So from the employment zone into the urban corridor business zone, particularly in the case of the 50-metre separation and that being an appropriate way to achieve an outcome. What I do think is appropriate, that someone's written that policy to say 50 metres is okay in terms of distance away from a residential property to mitigate the visual impacts of a 30-metre tower. Is 3 metres acceptable? Absolutely not. I think that the recommendation is proper in that respect. I think it sort of flies in the face of all of the urban corridor zone policies that talk about minimising visual impact to a residential zone, established neighbourhood zone. So for the reasons of that simplicity and my simplistic approach to it, I think it should be refused, particularly on the grounds of it not achieving its own policy.
Okay. Thanks, Will. Ruan, we're not talking consensus here because you're not necessarily.
I think I see eye to eye with essentially Rob's discussion has literally said, which is there isn't enough information on these alternatives. Like, as I agree with Rob, you could, you can't hide the elephant. Okay, we all know that, right? So you can't hide the elephant, but the impact of a loss of car parking over this being, what I can guarantee you is that this application is right hard up against the residential, very sensitive zone. But I don't have the information telling me that these other sites could have been acceptable with just a discount on car parking, which may well be a better outcome overall impact.
So at this stage, you're comfortable refusing the application?
Correct.
Okay.
I think the alternate site matter is a little bit of a moot point. We're looking at the proposed site 84 Main North Road. It's not considering other sites. It's proposing 84 Main North Road. That is inherent. It's not going to go options for other
No,
sites.
it's not giving us options, but the applicant has provided some indication of those.
Yeah. Okay. One site forward that
Yeah.
It might be no.
And I think that was my question to James Hilditch, is around, well, how much weight do you place on what might be available as an alternate site
under the development plan? Yeah.
Well, that was precisely my question.
That's right. Yeah. It's nothing to do with this application.
Okay. I don't have a differing view to any of the things that's been said by the members to date. I'm certainly not taken by applying the 50-metre separation guide because I don't think that is necessary, the requirement, but certainly we'll come back again to it with how the code is structured and the emphasis placed on various matters. I think this proposal is too close to an abutting residential sensitive area. So I'm comfortable with the recommendation as well. Are members comfortable with the grounds of refusal that have been put forward? And that we're saying that it's not seriously at variance, but offends the code to a significant degree.
I don't agree seriously at variance. So yeah, I agree with that position. Well, the only one, Chair, that I'm not entirely sure about is the height, the height exceeding the maximum building height requirement. That's the third from the bottom.
The last one.
Third from the bottom, dot point. So the height of the development exceeds the maximum building height. So just going back to James's comment about the definition of building height. Yeah,
it's a valid point.
And I think it's also the fact that I think, in my mind, with or without, whether or not that definition was there, I think I don't know if we can just say that the height might be required, subject to Rowan's comments as well, but it may well be required for the service. So.
What about the last dot point in terms of building envelopes then?
Well, the building envelope is different to the quantitative provision around building height.
I actually think because it isn't the building, I actually agree with. I think it was James Hilditch or someone who made that correction, and I'm 100% agree with that. Where this infrastructure is not a building, so we should delete. I think the height one and that mass one because they are actually. It actually weakens the whole argument. So.
Okay. Does staff want to make any comment on what has just been said?
I might make a brief observation. I think that one of the representatives spoke to the code being somewhat awkward in its dealing with facilities in zones where it's not envisaged is accurate. So in a zone where the facility is envisaged, like the employment zone, there's applicable policies set out through Table 3. We're bound in terms of those assessment criteria. I would observe that we're not able to assess car parking rates of the subject site if we were doing assessments in the employment zone because it's not a called up applicable policy. Whereas in this zone, where you don't have then within the zone telecommunications facilities provision speaking to height, whilst I agree that building height in terms of its definition doesn't include a telecommunications facility. So borrow from a representative, if we take that through to its logical conclusion, there can't be no relevant criteria about building height. So whilst it may well be, in my mind, relevant, as I think members have indicated, not to draw specifically to the TMV, I do think there is an extent to which height and mass and its relationship to the sensitive zone must be relevant to the assessment.
That's where I think that last dot point is still relevant. Height and siting the building in the building envelope requirements. I think that's relevant, but I think if you probably then don't need the TMV reference.
But a building envelope is there to mitigate impacts of building mass. This isn't a building.
I think it's a building. I think it's still a structure.
So to just call that through, in terms of definition of building versus building height, it's not within definition of building height.
Yeah, okay. Right. So the consensus is merely to remove as marked there for one reason. Okay, and everyone's comfortable with that? Okay, for the gallery's benefit, the panel has reached the decision to refuse the application for the above, for the reasons outlined there. Okay, thank you for your participation. Right. Members, do you want a 5-minute break? All right.
Okay. Do you need a break? Keep going.
We keep going?
Yeah.
Brendan, thank you. Okay. Well, we'll let the crowd participate.
I think we'll.
Thank you.
That's absolutely not true. Yeah. And the reality is, I thought about that.
Yeah. I thought about that as well. I did think about that. As you said,
So all of a sudden it goes from that's the only to these other ones. Yeah, except for the car park. It's just the end. And that's what I was thinking. The best place for that to be
really thrashed out as longer than you thought. Or, yeah, exactly. Yeah. And the wet in the yard. Yeah.
Okay. All right. Members, shall we move to item 7.1, 20 Toronto Street Prospect, a detached dwelling deck and privacy screen? It was a deferred item. Is Laura Cook?
Yeah.
Yeah. Okay. And Alexander's not with you, or he is? Okay. Right. Okay. As a deferred item, we wouldn't necessarily call you back again to discuss the matter. Right, members.
Questions? If there are
Question? Yeah, by all means.
Just a few quick ones. The David Brown advice, that was, I understand that was provided prior to further amendments to the application. Is that he was looking at an earlier design?
So Mr. Brown looked at the version that you saw at the previous panel meeting.
Oh, that's the same.
Assisted the applicant in preparing this final version.
Right. So that's the same advice as the. Oh, he looked at it's new correspondence on the original design that we looked at last time. Correct.
Yeah. So
and then it was
the
changed.
advice Mr. Brown had previously provided to this panel at its last meeting related to an earlier iteration of the plan. Advice now brought up to speed with the latest iteration of the plans as you had seen it. So it's just
Thank you for that. Just two other quick ones, Scott. On the plan, yeah, and there's some comments in the report about the separation distance of the driveway between the posts and the to go through. I'm assuming that's is that in part affected by the lily-pilly tree in the backyard? And I asked that as a follow-up question. Is that tree, can they remove that tree? Is it within 10 metres of the dwelling?
So in terms of the application, it's intended a desire to maintain the tree, which in terms of our soft landscaping and other policies has some relevance, notwithstanding that it is not a protected tree. The purpose of the assessment was to ensure in the context that we are building to the boundary of the right-of-way, that we're able to maintain a vehicular access through to that rear outbuilding, so there is an opportunity, even if it was not utilised for undercover car parking. The applicant has indicated that there is some intent to cantilever part of this deck or balcony and that would be further designed at building stage. It's not documented in these plans, but the intent of the condition is to ensure that if the lily-pilly is maintained as expressed, that there remains a vehicular carriageway through to that rear outbuilding.
Okay, no worries. And my last question, just quickly, the overlooking condition. Now, it's a little bit. It's not entirely finite in terms of, I guess. Probably a question more so. Is the expectation that the entire rear of that deck would be screened, or is that more of a come back to us? We'll talk about what we need to do for the rear of the deck.
Sure. Whilst I think that the simple solution would be to impose a condition requiring screening of that entire western facade to prevent those oblique northwestern and southwestern views, I don't think it's likely to be required to screen that entire edge of the deck in order to achieve the performance outcome of the code. Yeah. So the condition seeks to provide I think as you reasonably say, a somewhat uncertain, in the sense that there may be multiple design techniques that could be utilised to achieve it. Yeah. It seeks to allow a period beyond occupation because the topography is challenging to attempt to recreate these views on site now. So it seeks to allow an opportunity for compliance officer and myself to ensure that there's agreement between us as to reasonable satisfaction. We can land on that. That may mean projecting those existing proposed screens out in a longer path. It may be screening part of it or filtering views through louvered screens applied vertically. You can see a range of techniques.
So, Scott, why are you putting forward a condition rather than a reserved matter?
Because the reserved matter would need to be resolved before you could
issue DA.
Yes, yep. but more particularly, the challenging topography means having a view from that deck and seeing the extent to which it impairs the visual privacy of the adjoining property allows one to be more certain, where it is difficult to create that now.
That was my question as well. Okay, so the condition within 3 months. I can see why you've done what you've. Okay, yep. Okay.
Any other questions, Rob?
Just for my own benefit, with the right of way, in 314 it talks about, it's not a planning matter, but it talks about the owner of number 18 approving right of way. Does that affect the access in any manner?
Sure, and as you say, it's not a matter for this panel to assess, but certainly in terms of the design where it has, whether that be window canopies or downpipes or meters or other things that go beyond the wall of the building, and the wall of the building is situated on the edge of the right of way, the obligation on this applicant is to provide free and unrestricted through the entirety, through unrestricted access throughout the entirety of that right of way. They would not be doing that. But given that there is only one other property that has the benefit of the right of way, which is the adjoining owner, if those owners were in agreement, there is no reason why the Real Property Act would be offended by things like downpipes or other things existing. So in essence, the applicant, if they are not going to provide free and unrestricted rights of way across that entire width, would need to seek the consent of their neighbour, and if they don't obtain it, they would need to consider minor variations to retreat from that boundary to fit those structures within their unaffected property.
Thanks.
Anyone else want to raise any questions or start the discussion? Rob?
Happy to start the discussion. I'm supportive of the application in its current form. I acknowledge the changes that have been made by the applicant in response to the feedback provided by Council's Heritage Advisor. So I'm happy to support the application. I just have those questions that have been resolved. The only follow-up comment I'll make is, and for the panel to consider, is whether or not we just put an advisory note around that right of way matter. It's just an advisory note, just to make it very clear that there are separate obligations under the Real Property Act.
Sounds as if they're very well aware of it.
I mean, certainly the intent of identifying it within the report was to make sure that I was being as transparent with the applicant as I could be once I became aware of the matter.
Yep.
If the panel would like us to do so, I'm happy to insert a non-standard advisory note to that effect. But the panel would not need to resolve in that way. I would do that offline in the sense that they're non-statutory.
Yep. Yeah. Understood. Yep. Thank you.
Okay. Will, any comment?
The applicant should be congratulated for the changes they've made. It's clear that David Brown has worked with them very well in getting an outcome that fits in and looks nice and hopefully does what the applicant wanted to do. And I'm supportive of the application.
Thank you. What?
Yep.
Yep. Yep, is fine by me. Robert?
I agree. Look, I think the applicants have done a very good job. The advice they were given at the last meeting, they've come back and made those changes. Particularly, it's just my opinion, but the colours at the front facade and the materials are vast improvement. So I'm supportive.
Okay. To the applicants, we have panel's reached consensus and has determined to approve your development. To approve your development, okay? Right, members, let's move to the next item. This is the retrospective application at 29 Edgeworth Street, Prospect. It's alterations in addition to a restaurant. And that was previously given approval, and this is a compromise proposal based on the panel's refusal and the compromise proposal coming forward from discussions before the court. Is there anyone here from this matter? No? Okay, right. Members, open up for discussion. Robin?
Yeah, I'm happy to open up. I'm happy to see that the spa and the outdoor shower have been removed. Not quite sure what was happening there, but and I've read Sonus's report, and that's terrific for the back panel. I just query, like if you bring up the picture, that's solving the noise problem at the back. But I'm just wondering at the front here with the bar and outdoor dining at the front, whether that's going to have an impact on the neighbour to the west. I'm a bit concerned about that.
It's existing, I think.
Sorry?
That's existing. Approved, I think, that one. Bar at the front.
Yeah, can that be taken into consideration? Or
Not if it's lawfully existing.
Okay, fair enough. The hours are interesting as well, like 8 a.m. to 11 p.m. I mean, there's going to be breakfast, lunch and tea. I mean, I'm not sure whether we're going to control over the hours. And I'm also, it's okay that the owners are saying there'll be ambient music, but I'm concerned about how that will be enforced. I mean, I suppose I'm putting myself in the position of the neighbour as to the effect on them. If the music is louder, and probably hasn't been in the past, they bring the police and they turn it down that night. Other than that, the changes made are good at the back, and the SONUS's recommendations have been taken on board.
Scott, the manoeuvring areas shown in the report, to me they seem to indicate that you need more land to reverse and manoeuvre out in the forward direction. Am I reading that correctly?
I think, presiding member, that the intent of these drawings is to show that there are, if we take, obviously a 90-degree movement, whilst that shows the amount of area required for the vehicle to entirely reverse without turning from that space to begin with and then exiting a forward motion, that is one of a range of vehicle paths that may exist for that vehicle. The balance of those are shown here, and the 45 and 50, it is possible to make a movement in between those, I think is the intent of this drawing that allows access.
And in any event, these are likely to be staffed car parks.
That was exactly what would be my next point. So I agree.
Because you've now got parking available across the road.
Indeed.
Without restriction of numbers.
Indeed, and certainly this is speaking anecdotally, but we've been attending at North Park Shopping Centre for another matter between myself and our compliance officer, and so we've had an opportunity to take some regular observations of use of that car parking area, and it's not significant, if I can put it in those terms.
And given that it is already, has the use continued to operate during this?
The use, as in the activity within the building, has continued to operate, however, not within this rear area. It was for a period of time, but at a certain point in proceedings, we saw discontinuance of that area's use.
Right. So when would the noise measures be put in place? Like the previous condition that said within 3 months you've got to do this, is there any requirement for them to implement the noise before they get too far?
Perhaps relevant to note some of the background in that sense. So there is currently a Section 213 enforcement notice in operation restricting the use of the rear area. Until such time as there's a full approval in place, that restriction arising from the notice will continue. If and when the approval is granted, noting that the works are retrospective in nature and have been substantially completed, the condition applies immediately. So we would transition from having an enforcement notice guiding use of that space. Approvals granted, we would revoke the notice, and the condition takes over on the first day that the approval is valid.
Right. So what requirement is there for them to have to do the noise attenuation measures very quickly? Sorry, I'm being a bit thick here.
Because they can't use the space for their intended purpose until they have the acoustic measures in place. Right. Otherwise, they're in breach of the condition and we would undertake enforcement action.
Right, okay. And why is the condition there only relating to Sunday? Hours of operation for Sunday?
A day it sort of vary.
Yes, so this application doesn't include the remaining hours within the scope of this application, right. So we can't address the remaining hours through condition.
Through the chair, the current hours is till 10 p.m. on a Sunday.
Right. So they will continue on a Sunday for those sections, and this section will continue could operate to 11 or what?
No. So currently the site can operate 8 a.m. to 11 p.m. every day but Sunday. And current hours of operation is 8 p.m. to 10 p.m. on a Sunday. So they're proposing to extend the hours of operation by 1 hour on the Sunday.
And
for the whole facility.
Right. And that therefore does need some approval.
Correct, because the current hours are only till 10 p.m. on a Sunday.
And is that variation part of this?
Yes.
Right. Okay.
Hence the condition you see here, which then effectively replaces the previous condition of 8 p.m. to 10 p.m.
Right. Okay. And that's why we're only limiting patrons in the rear bar area, because that is already in place.
Well, through the chair, that's also part of the SONUS acoustic report or environmental assessment report recommendation. Also, no more than there are summaries based on there being no more than 40 patrons at the rear bar area.
Right.
And I must also add the only thing that's left off that list is stormwater disposal. Will also be added to the list of conditions if was supported.
Sorry, I've cut across people here. Rob?
I know it's been addressed, but I didn't quite catch it properly. To your point, your question to Scott, Don, around the acoustic treatments being in place, the timing around those. I know you answered that. Sorry, Scott.
So I'll go again. So we've got the Section 213 enforcement notice that applies to the date of approval. At such time that the approval is granted, if the acoustic measures aren't put in place, they will exceed 69 decibels, meaning they're in breach of the condition, which means we would serve a further enforcement notice preventing them from using the space. So essentially the momentum or the need to have the acoustic treatments applied is that they cannot use the space until those treatments are applied.
Yeah. Okay. And why then, if there is an acoustic level in place, why would it matter to us if it's live music or recorded music?
Because in the view of the acoustic engineers, the method of achieving 69 decibels is preventing live music.
Right, so it's, okay.
It's part and parcel of achieving these numbers, and that's inclusive of having the acoustic treatments there as well, physically.
Okay. Thank you. Right, sorry.
Sorry, one more question.
Yep.
I know it's getting late. Car parking for the original approval, was that approved with a shortfall of car parking for the original?
So, slightly complicated answer on this one. We were going through a subgenus land use change on the original approval from a shop, what was it called? The personal services establishment to shop restaurant. So we weren't changing genus of use, we were changing subgenus of use.
Yes.
Has some complexity with it also around how car parking rates applied before the sort of activity centre style zoning to when it became an activity centre style zoning. So in broad terms, if we wound the clock back to when this was first a personal services establishment, converting it to a restaurant is an undersupply of car parking.
Yep.
If we move to the activity centre model of shell of a building being used for one of the range of commercial uses, then there would be no assessment of car parking. It's just a change. Yep. So it's a slightly complex picture, but in old terms, it was undersupplied.
Okay. Right, it's going. One, what's your position?
I'm okay with it all. I think it's great that there's no spa and you can't have an Indian in the spa anymore. If I remember rightly, I can't remember what it was. It's a hot room or something.
So banal now. Okay. Robin, did you raise some points? But
yeah, well, look, there's no decision in that regard, is there? Well, we can't control the hours, or we cannot control the hours.
Well, you can only control the hours of what is actually subject to this approval.
So the singular hour that is proposed is to change Sundays operating in terms of closing from 10 p.m. to 11 p.m. That 1 hour is within the scope of our assessment to this application.
Okay. Just wonder why they've got such broad breadth of hours.
Well, that's not to say they will operate to that hour.
No, I know.
They just could.
Sorry, I should perhaps add to that then as well, that in terms of the way the zone now works, more about seeing a building as a shell and it being used for a range of different activities across its lifespan. In broad terms, this could be a brunch cafe tomorrow with no need for assessment from this panel.
Okay.
So in some senses, I think the range of hours is appropriate if we can contemplate it from the position of the lifespan of the building rather than this particular operation.
That's a good explanation. It doesn't mean they're going to be opening at 8. It just means
No.
Okay, thanks.
Anybody else need to comment? Will, you're comfortable with it? Yep. Okay.
Excuse me, Chairman, just a small note there in the dot point underneath live music. It mentions 5 metres from the performer. Just wondering whether that needs to come out because there is no live music there.
Measured at a distance of 5 metres from what? The speakers for recording music.
Just take out the performer and speakers.
Brackets. Thank you. Speakers. Yep. Everyone's comfortable with that? Okay. No one's here anyway, I don't think, but that has been granted approval by consensus. Right, let's move to, we've dealt with 8.1. Okay, 8.2, 39 Myrtle Street, Prospect. Is that what you're here for? Right, okay. Right, now, we do have a representative. Beryl, are you?
So she's just let you know that she's feeling unwell. Beryl's feeling unwell.
Yeah, she just.
Right, okay, and what has she?
She said that could the plan be different?
No, I'm not sure we could do that.
Yeah.
But anyway, unless the panel believes that it would be reasonable. But normally, if a representative can't come along, we have their written representation.
We have been said that we cannot guarantee that, but we'll inform them.
Okay, right. Okay. I personally believe that we should continue with this matter. Is there any contrary view to that?
I think the matter that she was present and we considered her comments through a piece of paper that she tendered. I think that would be more factual that she wasn't present.
Sorry, where are we up here?
So looking at the minutes.
I think we just need to note that the representative was not able to remain in the meeting due to ill health or something.
Chair, can we have read out what had been tendered?
This merely says to the President, re 39 Myrtle Street, health of Beryl means she is unable to continue here. Could plan be deferred? ? And it's signed by Beryl. Right. Well, I suppose the question is, does it prejudice anybody else?
Through the chair, if I might start by saying that the statutory timeframe to assess the application will be concluded before the next meeting of the panel. So you would need the applicant to place the application on hold in order for this panel to defer this application. Otherwise, it would be an automatic refusal in the sense that we would take those steps under delegation as you've set out to us.
And are you both willing to defer the matter and place the application on hold? And it can be whatever you choose. So I'm not we'll work to whatever you say.
I'd really love to have the opportunity to talk tonight and talk through the application.
Well, you won't talk tonight because Beryl's not here to talk first.
Right.
Okay. So we would not normally hear you as the applicant unless the representative is heard first.
Right.
We might have questions of you, but that's not a guarantee.
No, it's a new situation. You need to take it and trip.
through the chair, I think the comment, it was the first time on Friday that we learned of concerns that council raised. We weren't aware of any concerns, hence not putting it in response to the neighbours also pointing out that they were in support of the application with some minor concerns that with amendment. Based on that, we are here tonight to reduce certain walls and increase of landscaping. So we would be happy to defer if we're given the opportunity to make those amendments.
Yep. And I think, yeah, if you've got opportunities to compromise, maybe have some more discussions with your neighbour as well as staff. All I would ask, though, is that you place the application on hold.
And we did, subject to a phone call on Friday when we learned of council concerns at the time, request that we place the application on hold. So if that is suitable, we are willing to accept.
Okay, beautiful. Good. Scott, so that's okay. So the panel's happy to defer this matter until the following meeting.
So I think that's wise.
Thank you.
And we will in the short term submit.
Yes.
Okay.
Yep. By all means, keep discussing with staff the matters and maybe just keep Beryl up to date with it as well. Yep. Okay. Good luck. And thank you for staying so long. Right, members, I think we've got two other minor matters of noting. The summary of State Commission Assessment Panel. 8.3. Guys. Yes. Sorry. I couldn't work out, Brian, why you were here. Okay, let's move to page 668. 7 Brook Street, and it's a carport.
Thank you, Mr. Chairman.
Would your client like to come forward too?
I'm going to address the application, but in order to do so, I've got some photographs of, because this is an application at the moment, which is an illegal development. It's been built, and now the applicant is seeking retrospective approval for it. So, in a sense, you've got the benefit of seeing what has been built. And that's why I've got these photographs, which I'd like to, and I've got copies for each member of the panel.
Okay, so we can't put them on the screen, but...
Because I was told I couldn't, I sent them in this morning, but I was told I couldn't submit them until you, Mr. Chairman, had said you would receive them.
Okay. So, well, let's distribute them and we'll work from there. The applicant's obviously not here.
As I say, this is an application for what has now been built. And it's important to understand that that is the nature of the application. It is not what is said in the planner's report that it is an extension to the length of a carport. It's not that any longer, because it has been built contrary without approval. Now, in a normal course, if it was an extension to the length of a carport, one would assume, well, part of that carport has been approved and now they want to extend it. That's not the case here, because they have now built a new structure. In building the structure with the additional amount, they must be taken to have abandoned any previous consent they had for the carport, because they can't utilize it. And clearly, the law says that if you build contrary to an approval, you're deemed to have abandoned that approval and you want approval for the new structure. And that's what they're seeking here. Now, that's very important, because you'll see from those photographs, if you look at the first photograph, they're all numbered. Look at number 1. That was the development. That was the site prior to any development taking place. My client's property is on the bottom of that site, and you'll see the extent of landscaping, the pool, that's the subject site, the pool, and the veranda, which is not up to the level of the building line. That was what existed. Then the next photograph, number 2, shows a veranda which has been constructed at the back of the building. That's the subject of a different issue. We're only dealing with the carport tonight. Number 3, you will now see the carport as built from my client's property. The veranda, sorry, from my client's property. That's okay. Yeah, if you look at number 7, you'll see the carport as built from my client's property. That's number 8 is the carport as built. 9 is the veranda. And 10 is the veranda. And 11 is the carport now, which is built forward of the building alignment. And 12 is the carport built forward of the building alignment and to the height that you can see there. And number 13, you'll see where the old veranda line was, and the new carport built above that, well above the height of the and in number 12, you can see where the old carport came to an end. You can see the shading on the wall. So what you see now is the structure which has been built, which is a significant structure. It's not what you would regard simply as a carport, because if you look at page 670 of your planner's report, you'll see what the house was before. That was the outline of the carport before. And also, if you look at the report, page 689 of the report, there's a photograph there of the new carport. Looking at that would appear to be a garage. And it's now lined up with the building line of the building. And you can see it's in position on the next door property, which it overpowers now because it's been built up to the building line and interferes with the courtyard of the yeah. If you look at page 6, the photographs, which is the veranda which has been built, see there are lights embedded in the structure which immediately overlook my client's property, back garden, courtyard area. Now that's the effect of this new structure which has been built by the next door neighbour. So if you let's look at now the planning essence, the planning issues here. We see first of all that this is a fairly substantial structure which has been built as a carport, which has been built up to the front, up to the building line of the building. And then let's look at the assessment, because this is important. 10.1.2. The proposed carport will be ancillary to the existing building and would have a height of 2.9 metres, nearly 3 metres, with the height of the associated building and flat roof. The proposal is considered to achieve the building relevant provisions of the Planning and Design Code relating to building height, which I think is 3 metres. But when we get over the page to 10.2.1, we'll see the setbacks. Doesn't comply with the setbacks from the side boundary. It would have the failure to set the carport behind the building line results in the sandstone end retaining details being hidden. But more important than that, it results in my client looking at the roller door and its mechanisms and the carport from that part of the building line which has been exceeded.
So, Brian, if it was set back 500 millimetres as would normally be expected, I think that's what you're saying.
Because that, well, it was set back to where the carport was before.
Well, the carport set before was much further back than 500 millimetres.
Yeah.
So you're saying, sorry, Jenny, I'm not trying to talk around you, but if the requirement is a normally 500 millimetre setback, which would meet the code, are you saying there would still be impacts or not?
Yes.
There would still be impacts. Okay.
Still be that's the front veranda of our house.
Yep.
Where the carport previously was, it also had a roller door. The other people had a roller door. We didn't see that from our front veranda.
Yep.
So we also got light into that front veranda, and also our house has its internal, which is on picture 7. Our house has this internal courtyard,
yep,
which faces the neighbour. And again, you can see the line of the old carport, which is where it was before. That courtyard, that's looking at the wall inside our house. There are glass windows all along that, looking out to that courtyard. Again, all we saw was the top edge of the carport, which made a frame at the top of that courtyard wall. What's happened now is they have gone higher. So we now see the top of their carport. We see into their carport. Again, it's blocked the light that comes into that courtyard and subsequently into our house. And when that carport is lit, again, we get that lighting in our house.
The effect of what's happened is these people have built unlawfully, and they've built a structure which significantly impacts now on a neighbour's house in this way. Had they wanted to do this building in this way, they would have applied for approval, and we would have gone through the process of assessing it in a way where Jennifer now would have the opportunity to persuade you not to approve it. Now you're faced with an application which has been built, and we're asking you not to approve that because they've built unlawfully, and they must now accept the consequences of that if this building structure fails to meet the requirements of the code. And that's where I take you to the report, which shows in how many respects it fails to meet it. Indeed, the conclusion would suggest that it only there's a reason for approving it, because it firstly satisfies the intent of the established neighbourhood zone, even though the quantitative provision says it's not complying with the side setback. It wouldn't result in overdevelopment, but it does have an impact on neighbouring properties.
Brian, you continued the tradition tonight of speaking well beyond 5 minutes, but I think you've made the main points that you wish to make.
One of the things that's important, though, that I was going to mention, which I didn't get a chance, was those lights were embedded in the within the veranda. And just finally, the report suggests that it's considered to be relatively consistent with the relevant provisions of the code. My respectful submission that really, if you look critically at this, it really does not comply with the provisions of the code and should not be approved. And you should not be influenced in any way by the fact that the structure has been built. And the fact that it's been built gives you the opportunity to see how it has affected the neighbour.
Any questions of Brian or Jenny? Okay. Certainly the courts have made it clear retrospective matters shouldn't be in favour of them or shouldn't work against them.
But my point in this case is that the illegal structure that has been built is totally different from the quote approved structure.
Yep, I get that.
You have to take that.
Yep, good. No questions of Brian or Jenny? Okay, thank you. Okay. Members, any questions of staff?
I have one question. Yep. Just to be really, really clear, we are assessing the veranda at the back has been approved, not part of the application. The carport, for the most part, other than the extended section, has been approved, not part of the application. But just considering the extended period, the extended length of that carport.
Excuse me, can I allowed to make a point about the veranda at the back?
Go on.
The veranda at the back, the veranda that has been built at the back is not consistent again with the approval. As I understood that tonight's hearing was also going to discuss the veranda at the back, because once again, what has happened is the veranda that has been built at the back is not the veranda that was approved. The veranda that was approved, that was originally built there, is what I would call a Stratco veranda with little thin metal poles and a flat roof. Subsequent to that, the neighbours had proceeded to box in that veranda, and what we have now is an outdoor room, which you can also see in the pictures, which again is right on our boundary. If I need to take some further action apart from that, we do intend to do that, because again, that has also impacted on our property and has been built illegally.
Thank you, Jenny. Or Jennifer, sorry. Right. Question of what are we considering tonight? Scott, do you want to help us out here?
Precisely as Devashi indicated earlier, the change in length of the carport is the matter that's the scope of this application.
Thank you. And is that, as Brian put forward, the same is what is there now in total? Is the bit that was there before the same as what is there now?
If I'm understanding the question correctly, yes.
Sorry. Yep. Rob, stop laughing. Right. Okay. Right.
No?
No?
In what way is it not?
Hang on. Sorry.
So that yes, but if we ignore the bit that has been extended, I think is Don's question. Yes. If we pretended that the bit that was extended didn't exist, is the balance match the approval that was previously granted?
Well,
that was right.
The representative is saying no, it isn't.
For the carport, though.
For the carport.
Veranda is not looked into it or not assessed against anything. So they have been served a section.
So this is an application purely for the carport?
For the carport.
Extension.
And
45 metres.
Yep.
Yeah, extension. Yes.
Right.
Because it was approved prior.
Right. And the 1.5 is towards the front of the building, not at the back.
Yes.
Correct. Right. Okay.
7.6 was approved.
All right. And everything else that was there as a carport is still there as a carport now?
No, that's not correct.
Well, for the application, yes.
Well, their application is not correct.
Right. Sorry, Jennifer.
Sorry.
Yep.
Look at the photographs on the wall. You can see the print of the previous carport. That was what was there before.
you open to deferring this matter so that we get clarity of what was there before and what is there now, and what has been approved before in terms of verandas and carports and everything else? Or do you wish to proceed?
Yeah, there's a couple of things. I mean, I don't agree with this being approved at all, to be honest, because if this was never built and it came before us, we would never agree to the whole of the, garage building alignment all the way through. And then I look at
Sorry, Ryan. The panel you might disagree.
Oh, yeah, sorry. I would disagree.
Yep, but continue.
So I certainly, and I must say, I take it as a jump to go when I look through these things and we're looking at setback and, it's not there, and something recommending approval. So it was such a big jump for me to be reading the commentary and then going, the conclusions to accept it. And then I even look at the drawings, to be honest. The drawings are not up to scratch. When you look at the site plan, for example, which will become a stamp plan, of course, and it's showing as if there is a setback of the carport, but it's quite clear that there isn't. So, the drawings themselves are not right. So
that drawing shows the eave overhang of the house rather than the wall of the house.
Right. Okay. With that, it was clarified at the stage of verification that what is the current state, and it was in then written format given by the applicant that it is the eave and not the wall.
Is there a plan?
The way
it's on the next page, perhaps.
Yeah. So outside of the drawings not being,
there's no context to give us an understanding of what's beyond the photo, which is fine, but whatever. It's not a plan. I to concur with the chair's comment about deferring it. I think so. It's just there's inconsistencies in what the applicant is asking for, I think, and an insufficient amount of detail in what they're proposing too. That's my view. I don't know if
well, the thing is there at the moment.
Any difference, getting a better plan and clarity.
It's also not only better plan, but greater clarity about what is actually previously approved, what is there now, both in terms of potentially the veranda, although that's a compliance matter, not ours.
I think we should decouple those aspects. If there is an existing and ongoing enforcement matter that is not related to this application, we should not be assessing this application in relation to that matter.
Yep. Right. And the application is purely for the carport.
Correct.
Okay.
Built to the front.
Yes. Yep.
In the very bit that I don't like.
Yes, that's right.
And I feel that bit portion is actually why it's non-compliant with the actual setback, and it's quite detrimental because the flow-on effects is the impact to the neighbour property, the impact to the street alignment, the impact to the whole streetscape. So, the impacts just flow on from that one.
Is that just a typo in the background, though? It mentions that the carport was constructed 15 metres longer. Should that be, is that 15 or 1.5?
It's 1.5, so if there is a 15, it would be a typo.
There is a typo there. Yeah.
Okay. So it's just the 1.5.
So although the plan shows proposed attached flat veranda, that's not part of this.
No.
So these plans are, in broad terms, the same version of plans previously submitted, but for the additional length shown on the front of that carport.
Right.
And then subsequent changes to the elevations also reflective of the way that's been constructed.
Is there enough clarity for the panel to give an indication of whether it's, like Ryan is saying, it's not comfortable with this application at all in terms of its built form towards the street?
I think a zero setback on the side is acceptable. I think it's a fair proposition to allow someone to park their car under a covered area alongside that house. If it's 3 metres, which I think they're planning to do, I think it's inappropriate for them to build it flush with the building face when policies people said it should be 500 millimetres back. I think building on Ryan's comments about it, eroding, some of this, of its, minor departures, it is inappropriate. I think, if it were 500 mil back, then perhaps the zero boundary setback might be appropriate or more appropriate. But I think if it's presented, it's not a very compelling argument, and I would perhaps be looking to use it.
Okay.
It's just the incremental creep of all these little things which are not very respectful to the policy that looks for respect.
If we were to refuse, we'd need to be very clear about what aspects are we refusing this. Is it the overall structure in terms of its height, or just that front bit, and its setback from the house?
Meets the building height. It doesn't meet the side setback. It doesn't meet the building line setback. So I think that is the side setback acceptable if the front were pulled back. In my view, yes. It would improve the situation, particularly on the neighbouring property, as a result of less distance on that boundary.
Okay. Right. How are other people feeling? Rob?
I absolutely have no issue with this at all.
Given it's okay.
I will support this application, and I wouldn't feel comfortable refusing it.
Okay. So we don't have consensus, so let's move to more formalities.
I'll just make one comment.
Yeah, sure.
The point around the half a metre, is it the half a metre setback behind the dwelling facade? Yeah. So the building, isn't it achieving that? Am I missing something here? I thought it was.
Through the chair, this may be a matter of how building line is defined in the code versus how it was defined in the development plan. So under the development plan, building line was front portion of house, and that stretched across the entire front of the allotment. This would have met the criteria in relation to the development plan. Under planning design code, at each part of the building, it asks us to draw a new building line. So where this portion of the building steps back, that it becomes the building line for this portion of the allotment's frontage, and this is in line with that.
Okay. So thank you, Scott, for clarifying that. So notwithstanding, if you look at the views of the building from, if you're looking from the property from the right, it's screened. So the carport will be screened from the right where it's aligned with that section of the building. It's hard to explain. From one end, is there an...
It's with respect to the neighbouring dwelling.
Yeah, correct.
Setback.
Correct. Yeah, and I think there's vegetation along that front boundary as well. Yeah, so in terms of its impact from a streetscape perspective, because that's what that half metre setback's really about, is stepping it back from street to make sure
the carport being
less dominant than
the main dwelling.
Correct. Yep. So I think in terms of the view from the street, if you're travelling south, basically it achieves that outcome, because travelling south, the other section of the dwelling protrudes forward by at least half a metre travelling south. So it's hard for me to explain it, but I think it would have been more of an issue if the building was on the other side and it was.
But why are you taking it that you're travelling in the car? You might be also walking fast.
I don't think the half metre setback. I think that's what that half metre setback is really about. It's not about minimising visual impact on the neighbour, and I don't think this does have an unreasonable visual impact on the neighbour. In my professional opinion, 1.5 metres of that being extended forward. I think it's about minimising the dominance of the carport as used for the public realm. That's how I take that provision. But notwithstanding, I think Yeah, it sits flush with one section of the dwelling and it sits behind the other section of the dwelling. I just don't. And then it's on the boundary, but the existing carport's on the boundary. It meets the height revision. It's not adjacent the main usable area of private open space. Yeah, that's my opinion. So I'm supportive of the application. My only point was making sure that it's an extension to what has already been approved, that has been built in accordance with the approved plans. That's the only thing. Just making sure that it's connected to a carport that has been built correctly. Yeah, that's the only thing. So that we're not proving something that's.
Which is where we seem to have a disagreement.
I might just have a sort of comment in this part. Yeah. I guess it'd be feel for at least Rob to think about as well. But when I read this clause, and I'm just reading out of the officer's report, this 500 mils talks about carports, outbuildings. It's not talking about and garages. So, but it's a minimum of at least 500. Of course, it could be bigger because it's a garage that's got a roller door on the front, as opposed to an open carport. So you've got to read that clause properly, like, because it is a minimum of 500. Doesn't mean it can't be 1.5 metres, 2 metres. And then you read that in context of the other clauses that relate to the streetscape, your primary street walls, shouldn't exceed 45% of the building frontage, blah, blah, blah. It's all those things together means, well, that's completely at odds. So I would actually, suggest that, and I think certainly if Will was, I would certainly move to refuse it on the basis of, and we've got all these PC objectives, etc. there. Robin, your view, please.
Yeah, I think I'm in agreement with refusing it. Some of the pictures are hard to sort of pick up. I mean, there's the new roof in picture 7. I take it that's the continuation of the carport. Is only probably 300 or 450 mil above the old line, which was in line with the window there. So I'm not sure what was approved as far as height went in the original application. Well, we're talking with 1.5 to the front as the application, but we're not talking about height, are we?
The elevation shows the building height, so we don't need to turn our minds to it.
Yeah.
The previous approval was at 2.9 metres, so as it's proposed here.
That's built properly. It's just really the 1.5 in the front.
So whatever was lower was removed in accordance with the approval for the carport.
I wonder if maybe we're talking cross terms. So there was an existing carport, it was entirely removed.
Right.
There was a new carport that was constructed. So a certain proportion of that carport is reflective of an existing approval. There is a section that is not. They are seeking to vary that approval such that it relates to the length of the carport.
Right. And it's the length at the front bit that we seem to have different views about.
Effectively, the way I was looking at it is there was a line of the old carport forwards, and that's the bit that actually does cause the
impacts. Okay. Right. Will, have you've expressed an inclination to refuse? Okay. Right, members, we haven't got consensus, so can I have a motion, please?
Happy to move to refuse on the basis of the setback provisions and the straight alignment character clauses. I'm sure you guys can follow. For me.
Which are we? Is it PO 4.2 or something, isn't it? PO. Maybe check whatever you need to, Scott. Is that essentially it, Ruan?
I think there's a few other ones. There's the DTS, DPF, the 45% rule. One. And then there's the I would also do the design and appearance here, one that goes to the neighbouring line.
Oh yeah, I've got that highlighting. So
Remind me about the 45% you're quoting.
You're talking about being envelope?
No, there's the there's two of them, I think. There's the
it's F in DPF.
DPF
10.1 F.
11.1. Is it?
11.1. Sorry.
Yep. DPF 11.1. And I do notice that there's a side boundary one that talks about 27%, but I can't work out what it is.
Briefly, if I can, for you, Don. In terms of designated performance features, we have heard earlier tonight that they are one way of meeting or not meeting a performance outcome. So it is important that we express refusal reasons in terms of performance outcomes. So I understand there may be 3 reasons for refusal, and I have a broad understanding of the first 2 and not an understanding of the third at the moment. But if we could ensure that we're speaking about those in terms of performance outcomes rather than designated performance features, that would be excellent.
Fair. For me.
So PO 4.1.
In relation to, sorry, which issue?
That's to do with the character of the so you've got PO, I assume you've got PO 11.1. Related to that is PO 4.1.
Sorry, so PO 11.1 and PO 4.1 are related and part of one refusal reason?
Correct.
But it's still not that, is it? Yeah, okay.
Oh yeah, I see what you're doing. Okay, so it's actually the
it's 4.1.
So it's the length and the width, isn't it? So
where are you looking? In which provisions of PO 4.1?
4.1 is not even in the extra.
Called up for car in the E.
You've only got 3.1, 10.1, and 11.1.
Yeah.
And 11.2.
Yeah.
And essentially it seems to be PO 4.2, isn't it? That's the critical bit.
That's
the first
area.
Yeah. That's
not at the
correct.
provision. I think they need to be abundantly clear on that as well.
Yeah.
Which
That's what I was wanting to do was identify.
So yeah, the zone POs. PO. Again, zone PO 10.1 would also capture that half a metre setback from the building line as well. So I think that, it's already referenced in the character area
PO 4.2, but
So delete the 2 and 3.
Yeah.
Okay, so we have a mover. Is there a seconder?
Will?
Put that motion for refusal. Those in favour? Those against? That's carried. That matter has been refused. Okay. Now, can I get back to my point of the report? Okay. These two are the most boring reports I've ever seen. Scott, anything you need to say on any of these two? Or we just note them?
Yeah. Don't think so.
No? Okay. Noted. Everyone happy? Right. Any other business? Nope. Okay.
Next time, can we put the one that's going to take the longest last? I think we've made them suffer a bit, needlessly, but oh well.
We always work to the common good.
Yeah.